Check. Hello. Hello. Check. For motion, item number 1.
Yes, Lordship. Item 52 in the supplementary list, Lordship. Let appeal, Lordship, since the appellants were not made parties in the writ petition and the order has adversely affected them. So, lip appeal has also been filed. Seeking the leave of the court, this honorable court, to file.
How are you affected?
Agreed. Actually, the recruitment was done during the COVID regime. So the cabinet has taken a policy decision to make special recruitment. So advertisement was issued. In the advertisement, 5 posts were advertised. So we don't know which comes within the special recruitment type or which one goes to the entry. So we don't know. It is not mentioned even in the advertisement. So pursuant to the advertisement, in terms of the terms and conditions stipulated in the advertisement, we have applied for the post. And then we were selected, shortlisted, and then an interview was conducted. It was all during the COVID time. So advertisement was done online, open advertisement. So we were recruited and then extended from time to time. Now, the notification which was challenged on, that is 2nd November 2022. This notification.
The order of 14/5/2000.
Yes.
There I see the names of the persons at 11, 12, 13, 15, 16. 11 is black? No. The different person.
We are not, they are different persons, Lordship. And then the notification which was challenged, that is 2nd November 2022, that notification was issued in terms of a policy decision of the government, which was issued on 25th June 2020, Lordship. Page 162, Lordship. Page 162, paragraph 4, Lordship. This is the notification issued by the Health and Family Welfare Department on 13th of May 2022. Subject special relaxation of recruitment rules for special recruitment of health workers. And then we are concerned with paragraph 4. 162 paragraph 4. Relaxation was done as one-time measure for the special NPC recruitment right. We are junior dental surgeons.
So this is the judgment of past was in respect to the 5 posts.
Yes,
Of these 5 posts, the state has now taken the decision to look here, we are going to have only 3. Remaining 2 will be done by the non.
Lordship, in the government has filed an affidavit stating that categorically they have stated that this notification has been issued in terms of the cabinet decision, which was taken on 13th May 2022. And the imperial order was issued basing on this cabinet decision, that is 13 May 2022. This cabinet decision is also not challenged by the writ petitioner. Whereas,
Okay, that is another thing.
Lordship,
But now the government has taken a decision that 3 posts we are doing it by the special drive, but 2 posts we are doing by this. So I don't know, therefore not required, because the court did not pass an order.
Lordship, that is a pertinent question.
Yes.
That decision has not been taken by the government yet. But this honorable court, by the imperial order, has taken that decision.
No. This is what his submission is. Can you see paragraph 4 of the judgment?
Submission is contrary to the affidavit. Again,
No, where would that be? This is the order that has been passed. Can you see paragraph 4? Page 186.
yes, this was the submission by the councillor. Today, in the course of hearing of the case, Mr. N. Mozoy, learned counsel for the respondent number 2 and 3 on instructions, submits that the department will be making necessary correction in the Indian notification dated 2nd November 2022 insofar as serial number 4 relating to the 5 posts of junior dental surgeon is concerned by notifying that only 3 posts which was created by the cabinet in its meeting held on 23/6/2020 shall be notified for recruitment through NPSC by special recruitment drive, and the remaining 2 posts of the junior dental surgeon shall be recruited strictly in terms of Nagaland Health Service Rules 2006. Mr. M. T. Longtam, learned counsel for the petitioner, is not adverse to the submissions made by N. Mozoy, learned counsel for the respondent number 2 and 3. In view of the submissions made by the learned counsel for the parties, the present writ petition is disposed of with the direction to the state respondents, more particularly the respondent number 2 and 3, to make necessary correction in notification dated 2/11/2022 in respect of serial number 4, and to notify only 3 posts of the junior dental surgeons, which was created by the cabinet in its meeting held on 23/6/2020, be recruited through the NPSC by the special recruitment drive. The remaining 2 posts shall be filled up strictly in terms of the Nagaland Health Services Rules 2006. Now, Lordship,
No, if the government has taken now the decision that okay, we are going to only have it for 3 and 2, we are not going to have it. We are going to go ahead with the PSC. Then, the order which has been paragraph 5 was not necessary in view of the government's decision already taken. But Peter, as it means, it is the government's decision now.
Lordship, now, even though comply with the government decision, advertisement have not mentioned anything that these 3 posts should be go to NPSC and these 2 posts should 3 posts should be go to special recruitment drive. Of course, this examination is also to be conducted by the NPSC, and the remaining 2 is to be sent directly to the NPSC for normal recruitment.
So
Out of
till
the
then
5
government
posts,
has not
Lordship.
gone for a corrigendum. They have not issued a corrigendum?
No. Out of the 5 posts, now the difficulty is, Lordships, which three posts should go and which two posts should go to NPSC. In the appointment order, it is mentioned that where we are posted, but in the advertisement, it is shown command.
Have you
And-
already been appointed? Has the process of the advertisement
They are
and
working.
selection is over?
No, Lordship, because there were other litigation pertaining to the COVID appointment, Lordship. Now, this is the last case. Now, we are going ahead with recruitment, the special recruitment drive, Lordship.
No, but have you gone ahead with the recruitment in respect to this advertisement?
No,
So, no, advertisement has not been issued.
No.
Before we could go for advertisement, the impugn notification was challenged.
Lordship, what?
Do they have?
Lordship, that's exactly.
No, Lordship, the advertisement
That
which
was-
I am talking is
Post is not-
the initial advertisement during COVID time. During
Now
COVID time,
COVID is not a
yes, that is the problem, Lordship.
problem.
Human memory is so short-lived that during COVID time, everybody was running away. Even the doctors, nurses, they were resigning from the post due to fear of life. And we have sacrificed that, yes, whoever wants to join the render services, please come. We accepted the offer and we set for exam. And we were selected and appointed. And we are working till date. Now, our appointment has been done, a challenge. The advertisement was issued basing on the notification of 2nd November 2022. That was challenged by few doctors on the ground that, look, the relaxation given by the government, that is 13 May 2022. It's not proper.
When
all-
was your advertisement issued?
Lordship, that's the wrong section. No,
No.
in the requisition, nobody challenged the appointment. Nobody challenged the appointment.
No, understood.
Notification they have challenged.
Okay, where, no, show me where is your advertisement issued?
Page 18. In the advertisement, nowhere it is mentioned that these three posts should be recruited through a special recruitment drive and the two posts should go to NPSC.
Hmm.
The terms of advertisement do not say anything. It talks about only 5 posts and the petitioners in the writ petition has read for quashing 5 posts. But in the impugn order, with due respect, the learned single judge has made a distinction that 3 posts should go to a special recruitment drive and 2 posts should go to NPSC. So is it not going beyond
Now,
the prayers?
How do you connect this advertisement with the creation of a post done in the year 2022?
This was done during COVID regime, Lordship. As a
Understood.
special
Whatever may be,
dispensation.
the creation of those posts of 16th of July 2020 must have been done prior to that, or there was no creation, or was it subsequent creation,
No,
prospective creation?
no.
These are the same posts, Lordship, which have been
If-
continued.
If the matter is heard in sequence, Lordship, the sequence of even how the posts were created, how the advertisement was issued, which they are showing now, Lordship,
Hmm.
and how the government is notified for
Hmm.
recruitment under the special recruitment drive. Lordship, my learned friend has been saying which post to go
Hmm.
out of 5.
Hmm.
Lordship, that has been notified by the government during
Right.
the post creation. Lordship, can you come to page 160 of the read
160.
Yes, Lordship.
Lordship, the fact remains that we were appointed for a temporary period and we were allowed to continue. Now, government has decided to fill up this post by regular process through
Yes.
regular recruitment.
Lordship, in interest of public service, the government of Nagaland is pleased to order the creation of the various categories of posts under the Health and Welfare Department. This is on the basis of the cabinet decision for post creation, Lordship. This has been notified.
This is the junior dental engineering,
Yes.
3.
Yes.
So they have only created 3 posts.
3.
And what is this advertisement then? That is without
No,
creation
Lordship.
of post.
No, Lordship. Since the recruitment was to be done on temporary basis, there were 2 resulting vacancies in the department. And the issue at that point of time was the need of the manpower. So what they have done is they have included even the 2 resultant vacancy in the advertisement. And that is temporary, Lordship. Lordship, cabinet decision may kindly come to Lordship 158 page. That is prior to post creation, how the post has been created, Lordship. Page 158.
Hmm.
Lordship, may kindly come to serial number 4.
Creation of 3 posts.
Yes.
Hmm.
Now, Lordship, may kindly come to the next page again, page 159. This is the direction of the cabinet. All the newly created posts should be filled up by the head of family welfare department within a month time with proper advertisement. While filling up, this is how the marks should be given. Temporary appointment. B. The department should clearly indicate that this appointment will be temporary and regular recruitment shall be conducted through special NPS recruitment drive. So cabinet has said, for the time being, to tackle the COVID, this appointment will be temporary in nature. So they have included 2 resultant vacancies also. Now a guideline has been issued by the government, Lordship. Kindly come to page 161. How the recruitment will be done. This is 5th July. After the post creation on 2nd July, Lordship, this guideline was issued. On the recommendation of the cabinet by number so and so dated 25th June, the cabinet decision that I referred to, Lordship, the governor of Nagaland is pleased to frame the following basic guideline for recruitment. This is not to be done as per the service rule, Lordship. So these are the guideline issued.
This is a parameteria with the cabinet decision.
Yes, temporary appointment. Because we cannot do recruitment in terms of the service rule. Because the appointment was to be on temporary basis.
So if there is a NPSC appointment through special drive also, is there a mandate of having a particular advertisement and all?
Yes, Lordship. Now, on 13 May, which my learned friend has referred to again, Lordship may kindly come to my the read appeal at page 162. A proposal was sent from the department since the cabinet has already taken a decision for special recruitment drive, Lordship. So, taking in consideration of the selfless service and sacrifice made by those medical employees, Lordship, doctors, nurses, technicians, this was placed before the cabinet for relaxation of the service rule and the recruitment rules, Lordship. And recruitment rules only pertains to allocation of marks, Lordship. Lordship, may kindly come to page 163. Lordship has found the clause 1, the first paragraph, Lordship. Rule 15 sub-rule 1 to sub-rule 7 of the Nagaland Public Service Commission, State Civil and Other Services Recruitment Rule 2008, as amended from time to time, prescribed for selection to be based on written examination and interview, with the latter constituting 12.5% of the written examination marks. In relaxation of the prescription for the special
So
drive.
these will be the basics on which it will be done.
Yes.
There will be a written examination.
Yes.
Now, have you issued an advertisement
No,
pursuant to
that was challenged by different categories.
This was challenged. This was challenged on the basis that you are having 5 posts now.
Yes, Lordship. So, Lordship, the next page, 164. Even the post creation indicated.
Now,
Lordship,
kindly come to paragraph number 2 of that document, cabinet memorandum,
Lordship,
162,
160.
paragraph number 2.
Paragraph 2. Yes, Lordship. The newly created promotional posts were filled through promotion and recruitment against the resultant vacancy, as well as entry-level newly created posts was carried out departmentally. In addition to this newly created post, the department had also made appointment on engagement basis to the post which were created prior to 2020, but lying vacant for recruitment. Table 2, so and so. The recruited officers are engaged on contractual basis. And
So table 2 does not include junior dental engineer. Junior dental surgeon
Surgeons.
is not there in table 2.
Table 2, yes. 2 posts were not there.
Now, there was no post at all of junior dental. We are concerned with junior dental surgeon.
Surgeons, Lordship.
Can you see table 2 at 165?
Lordship. Yes, Lordship.
There's no junior dental.
Yes, the 2 resultant vacancies.
There's no.
No,
Okay.
no
then-
mention. So inadvertently, the 5 posts, which was initially advertised on temporary basis.
No, further if you can go there, laying back and therefore
Yes,
the recruited officers are engaged
engaged on contract basis, and their services have been extended as per laid down procedure of government. The department also represent for recruitment of 108 posts of doctors, 94 MOs, and 14 junior specialists, 3 posts of junior dental surgeon, and 21 posts of Ayush MO. 8 newly created so-and-so, and 2 resultant vacancies, 6 posts of research scientists, and 129 posts of staff nurse to MPC through a special recruitment drive, which is yet to be held. So
So
it
how
always,
do you get the 5 posts now?
5 lordship, as I have stated, there were already 2 resultant vacancy during the COVID time.
But that is not a part of, that is why I'm saying,
Yes,
if that is so, why it is not mentioned in table 2?
yes. Lordship, what has happened is like there's been some oversight, lordship, in doing the plus minus in the post, lordship. But going by the cabinet decision and the post creation order, it's clearly mentioned 3. So the writ petitioners, in the writ petition that they have challenged, they have not challenged the appointment of the appellants here. They are saying there cannot be any recruitment.
Have they been appointed?
They are on temporary basis.
Temporary.
Yes, still. So the contention of the writ petitioners was that you cannot do recruitment.
Beyond 3.
Yes. No. They were challenging the all 5.
Okay.
They were challenging the whole 5 posts that it should be sent to the NPSC. But we filed an affidavit justifying that 3 posts were created and 2 resultant vacancy. That has been added. If that's the case, lordship, then as per the cabinet decision, we cannot go beyond what cabinet says, lordship. Only the newly created post will be done through special recruitment drive. That is,
Just 1 minute.
lordship,
For the purpose of creation of appointment
lordship,
to those 5 posts,
lordship.
for example, let us take it at 5 posts.
Fine.
Or if it is done to be the cabinet memorandum, what is the procedure to be followed?
With regard to the special recruitment drive, lordship,
Yes.
as per the cabinet decision of 13,
Yes. What is the procedure to be followed? Is it required for would anybody else, apart from those persons who were
Yes.
appointed pursuant to that advertisement, would be called for?
yes, lordship, may kindly come to page 163, clause 3 again.
153.
163,
Ah,
clause 3. Though it has not been expressed, it's implied, lordship. Contractual employees, lordship, has found. Clause 3, Roman 3. Engaged by the government, including in NHM, this National Health Mission, the Nagaland State AIDS Control Society, NHK, etc., who have resigned during the course of COVID-19 pandemic or refuse to accept the contractual engagement shall not be eligible for any weightage for rendering COVID-19 service. So this goes to say that, lordship, those who have served, those contractual employees,
so
besides
those-
the petition, the appellants,
the appellants who have worked out there would be given the 25% marks.
yes,
If
And-
they were working.
yes, and also the contractual engagement of those dental doctors, because there are more than 100 plus, even in the National Health Mission. They also will be entitled. It's not that only 5 of them will get the post, lordship, no. Anybody who has rendered COVID duty will be eligible. So by filing this appeal, lordship, they are trying to show to the court that the 5 posts is meant for me and nobody is entitled.
That is why I asked you whether there would be a calling for other people
Yes.
also. Yes.
Yes, clause 3 says. It's very clear, lordship. It's not only them, even for the medical officers, Ayush doctors, staff nurses, all those who have served during COVID in government contractual appointment will be eligible, lordship. So basically, the recruitment that was done in 2020 during COVID.
So is it the stand now of the state
Yes, lordship.
that we are only going for 3?
3 years.
That's the
Because
strict-
2 we cannot bring, because as per the cabinet decision, only the newly created posts, not the resultant vacancies.
So your stand is just 3.
Yes, 3.
Lordships, the grievance of the petitioners in the writ petition was by challenging the notification of 2nd November 2022. Their grievance was the persons who were serving during the COVID will get a grace mark of 25 marks. And they don't want that to be availed. That is the only grievance of the writ petitioners in the writ petition. We are rather, in a way, supporting this notification of 2nd November 2022. Because this notification has given relaxation of 25 marks who have served during the COVID pandemic.
Where is the 2nd November notification?
Page,
Yeah,
2nd
got
November
it.
notification, page 43, 42.
Yes.
They have challenged this special recruitment drive. And we are concerned with serial number 4, that is junior dental surgeons.
Five
Number of
posts.
vacancies, 5, plus 1 candidate, NPSC. That is to be recruited by NPSC. And down below, Lordship will find in paragraph 2, the special recruitment drive shall be conducted by the Nagaland Public Service Commission.
But one thing, Mr. Jamil, let
Lordship.
us make it very clear one thing. The 26/5/2022 Cabinet Memorandum only stated about 3 posts of junior dental engineer.
Yes,
So how could a notification being issued for 5? Tell me. You see, kindly see the opening words. In the interest of public service and on the approval of the cabinet number dated so and so, the governor are pleased to notify the following posts to be recruited through so and so. If it is the basis is only 3 posts, how could they notify more? Isn't that an error being committed by the government?
Yes.
so Lordship,
We do
can
one
we
thing.
see?
Mr. Jamil, we do one thing. I'll give you the happiness of allowing your IA and dismissing the writ appeal.
That will amount to successful of operation and thank the patient.
Something like that. Because
Which-
obviously,
which-
you see, it is that now they have realized, yes, they have made a mistake. This was a wrong printing out there. They couldn't have made it 5 because the cabinet have only given 3. That is why I say table number 2, which has been enclosed as regards earlier vacancies out there, it only does not say anything about junior dental surgeon.
The 2.
Yes, there's no mention. The only help you are going to get is this court is, I'll only say to that effect, or we are going to say only to that effect that the last portion, having the government having now taken the decision, it will be at the way of the government to do whatever it is. And as such, the direction was not required. Now, therefore, later on, you can file a writ if you want to challenge the government's decision.
Lordship,
That is
can we
the
come
only
to
way
the
out.
prayer of the writ petition, in the writ
No,
petition?
writ petition prayer is there should not be any COVID duty and
The
all.
ambient order has gone beyond the prayers made in the writ petition also. That aspect may be considered.
No, not necessary, because the court did not actually. The court only on the basis of what Mr. Monjuri had submitted had categorically said that, look here, as it is now they have realized the mistake that the 2 posts were additionally put out there. So under such circumstances, now the only 3 posts will be there, let them carry out. Now, in fact, this notification is wrong. And the order of the learned single judge is absolutely correct on that aspect of the matter. But if you want to challenge the cabinet's decision, that look here, why did you make 3 posts or 5 posts or whatever, maybe they should have 5 posts because we were initially advertised for 5 posts, where will you go? So then obviously you can challenge it. By way of
Lordship,
verdict.
in order to give effect to the, in order to give effect to the order of the learned single judge also, there will be another difficulty. Out of the 5 posts, we are 5 posts, holding different posts. The court has directed to send 3 posts for special recruitment drive by the NPSC with a 25% mark relaxation, and the other 2 posts will send to NPSC. Which post should send to, which 3 posts should be sent to?
No, Mr. Jamil, have you been specifically appointed against a particular post, just for
No.
example, in Kohima? No, then how does it make a difference?
Lordship,
Tomorrow,
the-
if you are
and
happy out there,
if-
you
if-
go
if
there.
the appellant says so, the
Huh?
post to be sent to the NPSC is there in the
Yeah.
notification, post notified, page 160, Lordship.
Here it also doesn't say anything. Recruitment through the NPSC is a special drive. Only thing, what is the special drive being brought in? Is look here now, earlier experience, we will have 50% as marks as written, but we will also give additional marks for COVID. That is the requirement. That is why the special drive. In fact, as of now, the government may also say that we don't want it. Matter is over, COVID is gone.
Now, Lordship, keeping in view of the advertisement, the same terms and conditions were there. Who should be the sacrificial lamb? Who should be the sacrificial lamb out of the 5.
We then ask you to go to the district judge and file a suit and to find out who should be. Okay,
All 5 of us appeared in terms of the
which one
advertisement.
do you want? Allowing the IA? Or say that at all, then IA also is useless?
If I lost, I lost. If I win, I should win, Lordship.
No.
And Lordship,
No,
we
no,
kindly
because the
consider.
question is,
the-
it is the government's decision. They may go for that. Even just for example, can the court, I mean, just let us give you a simple example. There are post vacants. The government is not filling up. Can the court issue a writ, kindly fill up? No, that power is not there. Unless there is some gross arbitrariness or whatever may be, we can only consider, ask them to consider. That's all. This court cannot direct them for the purpose of kindly fill up all these posts. That is the
In
wisdom
spite
of
of
the
the
state.
order of the learned single judge, if the honorable court makes an observation to consider the case of the petitioners also giving liberty to the government, that will be a solace
No,
for
no, we will only observe to the
consolation.
effect. Okay. But Mr. Siti Jamid, the learned senior counsel, assisted by so and so,
I am Jim.
and Mr. M. Mujo, appearing on behalf of the
Respondent number
Health
2.
and Family Welfare Department of the Nagaland, the government of Nagaland, Mr. Mohammed Chun, appearing on behalf of the other state respondents. Huh? State respondent, number 1. This is an application filed by the applicants seeking leave to appeal against the impugned judgment and order dated 14/5/2024, passed in WPC number 36/2023. This court, upon hearing the matter at length, is of the opinion. No, this court, no. We, upon hearing the matter at length, are of the opinion that the leave which have been sought for ought to be granted. Accordingly, the instant application is allowed, thereby granting the leave to the applicants to file the accompanying writ appeal. I stands disposed. And now in the writ appeal. Heard Mr. Siti Jamid, the learned senior counsel, assisted by so and so, appearing on behalf of the appellants. Mr. M. Mujo, appearing on behalf of the Department of Health and Family Welfare, Government of Nagaland, and Mr. Mohammed Chin, appearing on behalf of the respondent number 1. This appeal is directed against the order dated 14/5/2024, passed in WPC number 36/2023, whereby the learned single judge, after taking into consideration the stand of the Health and Family Welfare Department of the Government of Nagaland, had directed the state respondents, more particularly the respondent number 2 and 3, to make necessary corrections in the notification dated 2/11/2022 in respect to serial number 4, and to notify only 3 posts of the junior dental surgeon, which was created by the cabinet in its meeting held on 23/6/2020. Through the NPSC by special recruitment drive. It was also directed that the remaining 2 posts shall be filled up strictly in terms with the Nagaland Health Service Rules 2006. For appreciating the facts in the perspective, this court finds it relevant to take note of certain relevant facts which led to the filing of the instant appeal. The appellants herein. Where is the document or advertisement you first produced?
Page 18,
18.
yes,
You were appointed in pursuance to this.
yes. It talks about only 5 posts,
Oh,
not
sure.
3 plus 2. And government affidavit says that this has been done pursuant to the government decision of 25th June 2020, page 24, where the creation of posts is shown only 3 posts of junior general surgeon. Only 3 posts were created, but 5 advertisement was
Okay.
issued for 5.
The cabinet of the government of Nagaland, in its meeting held on 23rd of June 2020, took up the agenda of recruitment of doctors, nurses, and other paramedical medical staff in the Health and Family Welfare Department. The cabinet, upon deliberation of the matter at length and taking into account the unprecedented situation arising out of the COVID-19 pandemic and the need to address the inadequacies of the state health system, including shortage of manpower at requisite levels, approved creation of various posts in the Department of Health and Family Welfare. The relevant, it is very pertinent at this stage to mention that at serial number 4, the cabinet decided creation of 3 posts of junior dental surgeon in the CHCs,
Yes.
amongst others, CHCs.
Clause B will also be relevant next page.
In
Page-
addition to that, huh?
Clause B will be relevant, page
Okay.
25.
Okay. In addition to that, the cabinet also issued certain directions to be followed while making recruitment to those posts. Which are enumerated in clauses A to I of the said cabinet memorandum. Clause capital, all A to I is all capital. Huh? Clause B categorically mentions that the department should clearly indicate that these appointments would be temporary and regular recruitment shall be conducted through special NPSC recruitment drive.
It do
You
not-
are referring to C.
No, B is, I'm referring to B because
B.
here it doesn't say about this much post,
Okay.
and the advertisement was issued pursuant to this notification.
Okay.
And the 5 posts were advertised. That is my
Pursuant thereto,
submission.
a notification was issued on 5th of July 2020, thereby framing the basic guidelines for recruitment and service conditions of medical officers, nurses, technicians, and other paramedical staff. The clauses A to I, which were of the cabinet memorandum dated 25/6/2020, were incorporated clauses the clauses A to G of the Cabinet Memorandum dated 25/6/2020 were incorporated in the notification dated 5th of July 2020. Pursuant thereto, an advertisement was issued on 16th of July 2020 for the purpose for recruitment on temporary basis through the departmental recruitment board for filling up 5 posts of junior dental surgeon. The said advertisement, however, refers to 2 notifications dated 26/6/2020 and 2/7/2020. Which, however, is not a part of the record. The said advertisement also stipulates the terms and conditions for the post of junior dental surgeon. And amongst the many, one of such condition is that the engagement shall be for a period of 1 year and can be terminated anytime with 1 month's notice from either the employer or the employee. It was also mentioned that the appointees through this recruitment drive shall have no right to claim for regularization of contingency service on any ground whatsoever. The appellants herein duly participated in the said pursuant to the said advertisement in the recruitment, participated pursuant to the said advertisement in the selection process. And they were
If Lordship is referring to page 21, appellant number
no, it's
one.
okay. And they were shortlisted pursuant to the appellants were appointed by the order dated 3rd of February 2021. Isn't that?
Yes.
For a period of 1 year, 12 months only, or till regular appointment is made through NPSC, whichever is earlier. The services of the appellants were thereafter again extended by another notification dated 16th of March 2022. For another period of 1 year or till the same are filled up through NPSC, whichever is earlier. Next. The record further reveals that a cabinet of the government of Nagaland took another decision on 26th of May. 26, no? 26 or 21? This page 162.
Page 162.
13th May 2022.
20?
13th May.
2020.
13 May.
13 May.
Yes.
13 May.
Okay. May 2022.
Lordship.
Whereby the relaxation of the recruitment rules for special recruitment of healthcare workers were discussed. It is very pertinent herein to take note of that in clause number 2, clause number 2, it was mentioned that the newly created post, the department would carry out the recruitment post. It was specifically mentioned only in respect of 3 posts of junior dental surgeon. Clause 4 of the said office memorandum further stipulates the manner in which the special recruitment drive would be conducted. A perusal of clause 4.1 shows that the selection to be carried out in the special recruitment drive would be based on written examination with weightage of 50%, there would be, semicolon, there would be 25% weightage in respect to those who have carried out COVID duty, semicolon. There would be 10% weightage for worker experience, and 15% weightage was to be given for interview. The manner in which the weightage were to be given in respect to COVID duty and work experience was also mentioned in Annexure Roman 4 to the said office memorandum. Pursuant to this office memorandum, The a notification was issued on, what is the date?
2nd November 2000.
On 2/11/2022. No, it is 26/5, not 13, 26/5. That office memorandum is 26/5. Because that is what has been mentioned out here, no? Kindly see at page 42. They have referred to this office memorandum. Not 13. Page 42 top.
No,
In-
Lordship, this 26/5 is the approval of the cabinet. Lordship, may kindly come to page. Because the proposal was sent, Lordship, the proposal,
Where is the approval of the cabinet?
Lordship, yes, page 170. This is the cabinet approval.
Kindly see this. 26/5 is okay, but meeting was on 25.
5 May. Yes,
25, not 13.
Lordship.
Cabinet memorandum dated 25/5. This cabinet memorandum was approved separately on 26/5/2022. Then you write. In pursuance to the said cabinet memorandum dated 25/5/2022, as well as the approval on 26/5/2022, a notification was issued on 2/11/2022, wherein the governor of Nagaland was wherein various posts were notified for recruitment through a special recruitment drive. Amongst the various posts, at serial number 4 was the post of junior dental surgeon, and the vacancy was shown as 5. In serial number 4, no, serial number, yeah. In clause 4 of the said notification, the manner in which the marks was to be awarded was stipulated. Footstep. The writ petitioners being aggrieved by the said notification dated 2/11/2022, approached this court by filing WPC number, filing a writ petition which was registered and numbered as WPC number 36/2023, whereby sought for a writ of certiorari for quashing the notification dated 2/11/2022 insofar as the post of junior dental surgeon, and further seeking a writ in the nature of mandamus directing the state respondents to fill up 5 posts of junior dental surgeon through the Nagaland Public Service Commission, strictly in accordance with the Nagaland Health Service Rules 2006. The edifice of the case of the petitioners were there. The said post, 5 posts of junior dental surgeon would not have been filled up by way of a special recruitment drive, which was contrary to the Nagaland Public Service Commission rules. You have a rules?
Health Service Rules.
Nagaland
Nagaland Health Service Rules.
Health service,
2000.
yes.
Prayer is in page
The
70.
said writ petition came up before the learned single judge on 14/5/2024, on which date the state realized that the notification dated 2/11/2022 was not in accordance with the cabinet memorandum dated 25/5/2022, the approval dated 26/5/2022, as well as the initial creation of 3 posts by the cabinet memorandum dated, wait, that first one, 21/6/2020. 22/5, no,
It's 25,
21/6.
page 158.
Wait,
158. 25th June 2000.
25/6. Right. On 25/6/2020. And as such, the council representing the Health and Family Welfare Department submitted before this court that the department would make necessary correction in the impugned notification dated 2/11/2022 insofar as serial number 4 relating to 5 posts of junior dental surgeon is concerned by notifying only 3 posts which were created by the cabinet in its meeting held on so and so, held on 23/6/2020, which shall be notified for recruitment through NPSC by special recruitment drive. And the remaining 2 posts of junior dental surgeon shall be recruited strictly in terms with the Nagaland Health Service Rules 2006. In view of the said submission, the learned single judge therefore disposed of the said petition with a direction to the respondents to carry out in terms with their submission so made before the learned single judge. In the backdrop of the above, if this court takes note of the submission of Mr. C.T. Jamil, the learned senior counsel, the learned takes note of the submission on behalf of the appellants, which have been forwarded by Mr. C.T. Jamil, the learned senior counsel, who submits that the petitioner, the applicants here, appellants herein were appointed on contingency basis for in respect to those 5 posts, and as such, the reducing of the 5 posts on which was necessary at that point of time on account of the COVID pandemic. The state authorities, having taken into account those 5 posts being advertised and the appointments so made, have therefore notified by notification dated 2/11/2022 the 5 posts of junior dental surgeon. Under such circumstances, the impugned order by which the special recruitment drive was only confined to 3 posts not only affects the rights of the appellant to participate in the pursuant to the notification dated pursuant to any recruitment drive carried out in pursuant to the notification dated 2/11/2022, but also the appellants would be deprived of the 25% of the weightage, which is there, which is prescribed in terms with the cabinet memorandum of 26/5/2022. On the other hand, Mr. and majority of the learned counsel appearing on behalf of the Health and Family Welfare Department, drawing the attention of this court to the Cabinet Memorandum dated 25/6/2020, whereby only 3 posts were created and the Cabinet Memorandum dated 25/5/2022, wherein also it was only in respect to 3 posts of junior dental surgeon, submitted that there was an error in the notification dated 2/11/2022 in mentioning 5 posts, which ought to have been only 3 posts. He therefore submits that in that, when the department duly realized the said mistake, the same was duly intimated to this court, and on the basis thereof, the order was passed on 14/5/2024. Anything else? Any? This court, having heard the learned counsels appearing, well, we have heard the learned counsels appearing on behalf of the parties and have given our due consideration to the relevant aspects of the matter. In the in the previous segments of the instant judgment, this court we have duly taken note of the office memorandum, the cabinet memorandum dated 21/6/2020, the cabinet's memorandum dated 6/2020, as well as the subsequent cabinet memorandum dated 25/5/2022, wherein it was categorically mentioned that the creation of the number of posts for junior dental surgeon was only 3. However, it is seen from the notification dated 2/11/2022 that the said creation that though the said notification is based upon the cabinet memorandum dated 25/5/2022 as well as 26 and the approval dated 26/5/2022 have mentioned that about 5 posts of junior dental surgeon at serial number 4. We have also taken note of the submission of Mr. N. Mujoy, the learned counsel appearing on behalf of the Health and Family Welfare Department, who submits that there was a mistake committed in incorporating the 5 posts, and as such, necessary correction has to be made. Under such circumstances, as only 3 posts were created for the purpose of special recruitment drive, the notification which was issued could not issued in pursuance to the office cabinet memorandum could not have mentioned 5 posts. Could not have mentioned more than 3 posts. Under such circumstances, we are of the opinion that the instant writ appeal filed directly against the order dated 14/5/2000, under such circumstances, we are of the opinion that the learned single judge was justified in passing the order dated 14/5/2024. Accordingly, we find no ground to interfere with the order dated 14/5/2024, passed in WPC number so and so. The writ appeal accordingly stands disposed.
Lordship, considering the practical difficulties to be faced by the department with regard to the 3:2, out of the 5 posts, which 3 should go to NPC for special recruitment drive and which post should be directly go to NPC? Since there are 5 persons,
Lordship,
keeping in view of that, if a direction is issued to the government, giving liberty to the government
Who are you?
to consider.
No, who are you to question that as of now? You are a temporary appointment. You have you are on contingency. You don't have a vested right to be appointed against that post. You have only a right that you are entitled to this 25%.
That is,
Lordship, the query put up by the Maryland Senior Counsel, Lordship, is covered by page 160, the creation of the post, the notification. If that can be reflected, Lordship, then that will solve his problem. Because in page 160, the government has notified the 3 posts that was created by the cabinet during COVID. Page 160. Still,
but we have appointed 5.
No, Mr. Jami, I don't want to deal with that argument because if I deal with it, I'll reject it. Now, if I reject it, we'll have no fun. Let's leave something for the future. You still have, I can give you one liberty. Before parting with the record, this court, however, observes that the petitioner herein that the dismissal of the
Appellants.
instant appeal shall not preclude the appellants herein to challenge the decision of the respondents in creating only 3 posts or creating only 3 posts in respect to the special recruitment drive.
I cannot question the creation of the post. Lordship is well aware, creation, abolition, there's a prerogative of the government. I have no grievance on that. But out of the 5, which post should go to
But
NPC?
first of all, do you
and-
have a right? Which post? There's no right to that effect. You don't have a right that, okay, this post will be. Why? Do you want the continuation from your post where you are working?
But the advertisement was common, 5 posts.
So did the advertisement initially?
So we are 5
But
appellants.
Mr. Jami, tell me, did the initial advertisement on 6th of July 2020
Lordship,
say that about the 5 posts, did it say which post? No.
we can
Page 18, it does not say so.
This cabinet memorandum is about 3 posts.
No, page 18, I will see. That is why I'm saying this advertisement is not based upon the cabinet memorandum. That is also I've dealt with. It is on the basis of 2 notifications which is not a part of the record. Yes. Should I require the leave? Before parting, should I put it? That doesn't look nice. Unless you want it, that okay, legally nothing happened, let us do something. What is the second? Second is for stay, I suppose. I stands closed in view of the dismissal of the disposal of the.
For admission, item number 2.
May I please, your lordships?
Yes.
I'm appearing for respondent number 2, 3, and 4, who is the nodal department for implementation of the scheme lordship. Now, by order dated 21st to 2024, respondents have been given liberty to file affidavits with regard to the communication to the ministry as well as the present status. So I have received a communication from the
Yes, yes,
ministry.
madam, first read that order of 21 to 2024. What did I say? Have been filed by the petitioner bringing to the attention of this court that in the state of Nagaland Yes, who is paying for the state? Yes, what is the state of affairs?
I am the Nodal
You
Department,
have what
Lordship,
you will treat.
2, 3 and 4, Lordship. The
Who is
Department
who?
of Social Welfare, Lordship.
Okay. What is your stand now? You have made
Lordship,
the
so-
verification.
Lordship,
You have made the verification.
Lordship, it's under process, Lordship.
No,
However, we
you
have
said
received-
that you have already completed the verification earlier. You have sent it to the ministry and the
No.
ministry is not working out there.
the Lordship, of the 198 beneficiaries that has been filed by the petitioners, Lordship,
Hmm.
we have categorically mentioned in our affidavit that out of the 198, we have verified and 60 were availing.
60?
60 beneficiaries were availing out of the 198 beneficiaries filed by the petitioners. Now 60 were availing, and out of 136 remaining, one already died, and one was found to be a retired government teacher who was availing the pension, who is not
Retired.
actually indicted, Lordship. And so.
What
the-
about the others?
So the remaining
136?
out of 136, 44 were already included already, and 10 already died. And
10 died.
82,
How many have died? One has
10.
already died out of 138.
And
Another
the
10 have
remaining,
died
the
under
s- in the-
138.
in the second Lordship. in the
You have
second
filed an
verification.
affidavit.
Lordship.
So the-
June,
To that
Lordship.
effect, Lordship, but then as if you see the order 49 2022, Lordship, this court has specifically they have made a mention before the court that for the entire state, the verification is going to be conducted within 3 months.
Oh, you are
So the
only,
court-
they are only limiting to your case,
Yeah.
your petitioner.
No, Lordship, in fact, the petition concerns the whole state. However, during the course of hearing to assist this court, Lordship, and also to assist the department, because we also got information that verification is going to be done. So with the help of a pro bono club, which is petitioners has sought the help of the pro bono club from Kohima Law College. So along with that, the list was compiled and 198 beneficiaries could be identified, Lordship. So if
So they could only identify 198.
no, Lordship. From our side, Lordship.
You
From
have
our side,
identified.
we are assisting them, Lordship. So this court has said that since they are for the entire state, the lease will be more, Lordship. So they said that they'll be conducting a verification for the entire state. So this court has specifically directed on 14/9/2022 that at the time of verification, Lordship, the lease that we have given placed before this court, 198, case may also be verified and be included if they are found to be eligible. And the court has specifically directed that the compliance report be placed before this court. Now they have filed their affidavit, but that was only confined to the 198 list, Lordship. Whereas the verification report for the entire state is, they have not placed it before this court.
It is a central government scheme.
It is, Lordship, it is.
Now, here, what is the duty of the state? The
Dut-
state is going to make the verification.
Yes,
and
Lordship,
Also see they are the implementing agency.
yes,
Money will be paid by the central government.
yes, money is paid by the central government.
And
In
the
fact,
central and the state government is not doing the need.
yes, Lordship. Now, Lordship, there are two categories.
Who has filed this affidavit on behalf of the respondent number 2 on 14/9/2022? This affidavit was filed on 15th of June 2023. There you have given these details.
Lordship.
There you have said, on the other hand, just now you said 60 are awaiting. Here it says that existing beneficiaries. Page 4 of that affidavit. 60 are existing beneficiaries.
Lordship.
136 is not.
Not
uh,
availing,
Are
Lordship.
awaiting, are not under the NACP scheme.
Lordship. So accordingly, we have sent a proposal for inclusion, Lordship, to the Ministry of Rural Development, who is not actually a party in this petition, Lordship.
Then what happened?
So, Lordship,
Central-
court has been. court
Because
is-
last time, if you see my order, which we have passed an order.
Lordship, we have,
Wait here on the last occasion on 21
Lordship.
2024.
So in compliance with that, the department has brought to the ministry, and the ministry has sent us a communication, which actually we have to require to file in the form of affidavit, Lordship.
Madam, in this process, people would not get any pension, all will die one fine day.
Lordship, but the
This
ceiling,
old age pension is those people who are in a who are to be paid, and they are obviously a particular age.
Lordship,
Particular
actually,
age.
Yes, Lordship.
Lordship,
60 above, 60 and above, Lordship.
Lordship, the problem
We will
that
see the other PILs, there also there is problem with health. Health is not doing it, so under, you are not giving proper health. The next consequence is, on the other hand, you are also not giving the
No,
proper.
but with regard to the implementation of this all age pension, there's a ceiling from the ministry, Lordship. It is not that
Then
we,
why didn't you bring it? I
Lordship, so-
directed this thing to be brought on by 13.3. And the
Lordship-
matter has been just, thereafter, every time prayer has been taken on behalf of whatever the adjournments have been happening. Then how do you take care of this?
Lordship,
The IELTS are to be taken up as urgently as possible. While you have affidavit.
the petitioners were also directed to implement the necessary party who is a Ministry of Rural Development.
Lordship, already
Till
on
date.
14th,
I have already
14th,
taken
you have
for partial
completed, Lordship, yes,
opinion.
yes.
You are there.
Initially, they were representing,
You have
Lordship,
not received copy.
Yes.
Lordship, initially they were representing Ministry of Social Justice Department.
Madam,
We can give them a copy if they require, Lordship.
okay, madam, did you make the fresh memo copies?
Lordship, I have to inquire from the leading council. The leading council is indisposed.
No, no,
So-
no, you are, for us, you are the leading. So kindly, here, 21 to 2024, I asked you to make the file a fresh memo copies. Do that.
Lordship, that is not in my knowledge, Lordship.
This is the problem. No, I have made the party. Union of India, Ministry of Government of India, Ministry of India having its office at Shastri Bhavan, New Delhi at the response number 7. I made them a party. Now, what did these people do? Let's see. Here can happen like this. Okay. Madam, you have filed it.
Lordship,
Yes, you have filed it. You have filed it on 22nd of February. You have filed it. So then you have given a copy.
we will give them, Lordship.
Okay. When do we take it? You
Lordship.
file your affidavit.
Within a week's time, I'll be filing Lordship.
Next Wednesday.
Next week, Lordship. It's a fixed item.
File your
Lordship,
affidavit.
Lordship,
Give a copy to. Mr.
yes, Your
Yadav.
Lordship.
Your, when so, the learned counsel appearing on behalf of the respondent number 2, 3, and 4
Four.
submitted that she has not certain, that the state respondents have received certain documents. But from the Union of India, from the Ministry of
Rural Development,
Ministry
Lordship.
of Rural Development, which would have a vital bearing on the state PI. It therefore submits that some time may be given to bring on record the same state document by filing an affidavit. Mr. Yangavati, the learned counsel appearing on behalf of the respondent number 7, submits that no copy of the petition has also been served upon him pursuant to the order passed by this court on 21/2/2024. Ms. Swenson, the learned counsel appearing on behalf of the petitioner, submits that the copy of the PI shall be duly served upon Mr. Yamavati during the course of the day. Taking into account the above, this the matter again on. No. We are not disturbing you for the time. Let us get what I have. Well, otherwise things don't move. On 12th of June 2024. Gustav, the respondent, the council, the respondent number 2, 3, and 4 shall file their affidavit bringing on record the said documents on or before 11th of June 2024 by serving advance copy to the council for the petition.
Obliged, Lordship.
For admission, item number 3.
Yeah, please, Your Lordship. Lordship, I beg to mention on behalf of the government advocate Tivapong, as is indisposed, I pray that the matter may be fixed on coming year.
Mr. Council, we will disturb you first. Let us be satisfied with him. Who is the appellant?
taking the consent of the,
Who is the appellant? He.
yes.
Let us be satisfied. We have to see as to whether we should admit it or not. Tell me,
Lordship, I'm appearing on behalf of my senior. And I have no objection.
who is your senior?
Mr. Chindiana, he wouldn't be here today to do some personal.
This is the interim order. So this retrospectively regularize the petition.
That's all.
When do you want it?
After 2 weeks.
The request of the every time you are asking time, last time also. When is the good lucky day for you? Obviously, there has to be a lucky day. Huh? You adjourned it earlier. At the request of the learned counsel appearing on behalf of the appellant, matter stands adjourned to be listed.
For 2 weeks.
Sign it there. The adjourned sign it there to be listed whenever your appellant mentions. Be listed after in the first week of July 2024.
Thank you, Lordship.
That would be third July. First week of July.
Hello. For admission, item numbers 4 to 37.
That's
Yeah.
Lordship, as per the direction of this honorable court, by order dated 13/9/2023, we have filed a status report of the 24 health units. There are 34 PIs also, analogous with regard to the manpower, the infrastructures, and the medicine availability to Lordship. We have annexed the documents, Lordship. Now, as far as the medicine is concerned, Lordship, almost all the receipts are in handwritten, Lordship, and it's coming to a big bulky document, Lordship. But we have stated in our affidavit, Lordship, as per the direction of the Honorable Court, Lordship, we have the requisite manpower as of now with the infrastructure and as the medicine also.
What is the PL for?
Lordship, it's with regard to different health units
Ah.
where the allegation was made that we don't have the requisite manpower, infrastructures, and medicine availability. Now, Lordship, for that matter, COVID was a sort of a blessing in disguise for the department, Lordship. We could get 360 post creation. The dental doctor, Lordship, that's one of the posts. 360 different category of posts has been created. Altogether, 120 medical officer, junior specialists, senior specialists, and MOs. Then we have 11 Ayush doctors. Likewise, 360, which we are going to do the recruitment. That will suffice to our requirement as far as the shortage of manpower. Because we have stated in the affidavit, in the earlier affidavit, that we don't have the requisite manpower because there was no post creation. Now, Lordship, because of this 34 PIL, this Honorable Court, the Honorable Chief Justice has taken suo motu.
This one?
Yes, of the medical college, the establishment of the medical
that
college.
one.
Yes,
Has it been done?
yes, it's running, Lordship.
It's running?
Yes, Lordship. And then we are going for the second batch, second year. So, with that, Lordship, I have already given my status report. A copy has been already been served to the petitioner also, Lordship. So different health units, Lordship, I have annexed the documents.
This PL, all these are
Yes.
different
Different
districts.
health units, yes, throughout the state.
Okay. So what is your affidavit? Which one is the last?
Lordship, the affidavit was filed on 23rd of April, 2024, Lordship.
Huh?
24th of April, 23rd April, the last affidavit. It's the bulky one, Lordship.
23rd of April.
Yes, Lordship. Lordship, we have given we have annexed the manpower, medicine availability, and the infrastructure, Lordship, of the different health units. A list was furnished by the counsel for the petitioner, Lordship. The same is placed for the court also. List of 34 health units. That includes 5 district hospitals, then 14 primary health centers, and 10 sub-centers, and 5 community health centers.
Okay. Then, as per this affidavit of 23rd of April 2024,
Lordship.
you have not till now filled up. And as we can see from the first matter which we have taken,
Yes, Lordship. But already,
you have not yet issued the advertisement.
yes.
Yes.
But those contractuals, Lordship, they're still in place. The temporary engagement, they're still in place.
Understood, but then also you have not filled up. If it is, this is your, you could have very well said that these are the persons who are very much there now.
Lordship.
So there is no requirement and we are going to go ahead with a special
Yes.
recruitment drive which is happening out there. That
Yes.
is another aspect.
Yes.
But did you say in your affidavit that all these hospitals out there have the recruitment part?
Yes,
Your
Lordship.
specific statement out there in paragraph number 3
Lordship.
of the said affidavit makes it very 3 and 4.
Yes.
4 says, let me see. That mention may be made that during the COVID, the government has created various posts from the departments of so and so, so and so, so and so. These posts are in the process to be filled up.
On regular basis, Lordship. I have,
Understood. But where have you mentioned that they are already there?
Lordship, if Lordship may kindly see that earlier appeal, because they were appointed.
You
yes.
are taking steps, but as of now, that notification is yet to be corrected of
Yes,
20
because
of
yes,
2022.
already with the government Lordship, it will be corrected very soon. Then we are sending for requisition to the NPS
So
for regular
what,
recruitment.
what should happen in the meantime? Should the people keep on suffering on account of
No,
manpower
no,
not being there?
already the contractors are there.
So
those
that has, why you have not mentioned that there are, all these things are duly covered by that, that should have been your
Lordship,
affidavit.
my apology, my
So your affidavit is not clear on that.
Right, Lordship.
When are you filing an affidavit? Then? Give me 2 weeks time to file your affidavit. File an affidavit or 3 weeks time, give you an affidavit file that in these hospitals in respect to these PIs, which are
Lordship,
concerned,
yes.
that you have this requisite manpower and for the purpose of subsequently, we are all, the government is also taking steps for regular
Lordship.
appointment.
Lordship, if I may
Because
be allowed,
those appointment orders which I could see,
yes.
those have been extended stating 1 year or till the NPSC recruitment drive is not done.
Lordship, as far as manpower is concerned, Lordship, just an example at page number 11, Lordship. 11. Status of manpower under Kohima district.
Yes.
Status of manpower, Lordship. Lordship, can you see? Health unit under Kohima, number 1.
Konoma.
Yes. We have Dr. So-and-so, MO, so-and-so staff nurse, A&M, Lordship. As per the requirement, we have placed the manpower, Lordship, under Kohima district, Lordship. Likewise, for again coming to Woka district, page 18. Yes, Lordship. Manpower, Lordship, will currently come to page 24. The doctors, the staff,
Where is the
nurse,
manpower thing?
page 24, Lordship. Lordship. Page 24 and 25. Then page 26 again, on the Rio PHC, page 26, the
Yes,
manpower.
madam, you have received a copy of this. What do you have to say then? Although what is content in the content of the affidavit is not so satisfactory.
Yes,
But what
Lordship.
do you say about those documents? Have you made any verification?
Lordship, actually, it's quite bulky, so I was also updating the petitioner's Lordship and seeking instructions. Lordship, one of the
That was
key,
done- that was given in the month of April, we are in June.
Lordship, now, since one of the key issue that is raised in the petition was the manpower and specialization, especially as far as medical doctors are concerned. So I also got information that recruitment will take place in huge number, Lordship. So I was also of the opinion that if that is done, these petitions can be closed, Lordship. But as this honorable court has rightly pointed out that since the affidavit is not very satisfactory and is showing that manpower,
But the documents are there.
Lordship, yes.
This is a PI, so we cannot be so technical with this lordship. Like I am not.
Yes, your Lordship.
I leave it to Lordship.
Lordship.
No, he has already given you verified.
Lordship,
As
yes.
regards
In that case, Lordship. Otherwise, so much could have been achieved with the intervention of this honorable court,
So
Lordship.
the learned counsel appearing on behalf of the petitioner in the various, in the instant batch of public interest litigations. That she'd like to make, she seeks for some accommodation for the purpose of carrying out a verification in pursuant to the enclosures to the affidavit filed on 23rd of April 2024. She submits the 3-4 weeks time would be required.
Lordship.
List the matter again on 3rd of July,
Lordship.
Lordship.
3rd of July 2024. In the meantime, the petitioner shall make necessary verification, and if there are any deficiency, shall bring the same by way of an affidavit.
Obliged, Lordship.
Item number 38. May I please your lordships? Lordship, I'm from the respondent number 1 to this writ appeal, Lordship. Lordship, I pray may be gracious enough if I may be granted 4 weeks time to file my affidavit in reply. Lord.
What affidavit in reply to writ appeal?
Or
Is it conceivable?
Lordship, and also
Tell me.
we have not filed our Baglatnama as well, Lordship. Even the Baglatnama, Lordship.
You have not filed the wakalat number.
Lordship.
So then
because-
why should I hear you? Who are you? One number 4. Here's my, you are challenging what?
My lord, challenging the order dated
Huh?
4/7 of 2018. The learned single judge has passed an order that we should have to conduct a fresh census and respect to
You are
The-
the petitioner.
appellate. I'm the appellate, my lord. And the
Who is the-
petition, I'm the respondent, my lord.
Who is the petitioner?
They are the petitioners, my lord.
The writ petition, Lordship.
What is your stand? Admit the year, also year, so as to why they include census of demand to the provisional population in Nagaland. Different direction. Let's see, what does the learned single judge do?
My lord, the learned single judge has directed us to conduct a fresh census, my lord,
Who are
within 3 months, my lord.
You are union.
Yes, my lord.
Let's see. Where's the single judge judgment? Page. Two 2018,
Yes, my lord.
158.
Yes, my lord. 158, annex 4.
Let's see what the Supreme Court has to say.
Page 164 board, my lord, annex 5.
Page
164.
171.
Annex 5, 164, annex
171.
My lord, 171 is in regard to clarifications of the order passed by the Honorable Supreme Court. My lord.
Who does it? The census? Hmm? Who does it here? The census is done by whom? How does the Supreme Court's order has any relevance here?
My lord,
There's a stay.
there is author appeal also, my lord.
But who is paying for the Election Commission of India here?
My lord, here election commission this is not present, my lord.
Who?
Election Department of Election is not included, my lord.
Then who appoints? Who appears?
Actually, their case is over, my lord. Their case is over because that they are allowed to conduct electoral census, my lord.
No, the census official, director of census, you are appearing. You are appearing for the director of census.
Yes, my lord.
What is his, why has he not done the census? Has he done the census in terms of?
Well, my lord, in terms of census, we have done it.
Then,
We have done it at 211 census, my lord. And upon the challenging that 211 census, the petitioners has challenged that 211 census, saying that the population, that particular values population is less than previously previous population, my lord. That's what the petitioner has challenged. And about that one,
okay, we do one thing. We admit the appeal and list it for hearing. He appears for respondent number 4.
Respondent one.
Respondent number 1.
Lordship.
Others we are not necessary. Only one respondent.
Yes, Lordship.
yes,
Okay, I think this is the case. We admit the appeal. What do you say? You want the dismissal of appeal? Okay, admit it. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner and Mr. So-and-so appearing on behalf of the sole respondent. This court have duly taken note of the submissions made by the learned counsel for the appellant, wherein wherein whereby he has submitted that the censor that the judgment and order dated 4/7/2018 directs the appellants to conduct a fresh census with regard to the Kitami village of Zunhibeboto district, Nagaland, within a period of 90 days
Yes,
from the date of receipt of the order of the court. He submits that the census of 2011 was done in accordance with the directions which were issued
Registrar General Census Commission of NTMI.
by the where's that document? I couldn't find it. Where is the director of census? I could see some document here. Oh, yeah, here it is. Was done in terms with the directions issued on 1st of March 2010. Taking into account the above, this court is of the opinion that a case has been made out for admission of the instant appeal. Accordingly, the writ appeal is admitted for hearing. The matter be listed for hearing on 10th of July, 2024.
Lordship.
Yeah.
Much obliged, Lordship.
For admission, item numbers 39 and 40.
On the last occasion, Lordships, the learned CGC sought time to file affidavit.
I have filed my affidavit in item number 40, which will cover item number 39 also.
Yes, I asked you to file an affidavit. What happened?
Lordship, the affidavit in item number 40 will cover 39 also.
No, PL 23. We asked the State Health Commission to file the affidavit because we have found at that point of time it was not in accordance with.
Yes.
Yeah.
Lordship, I filed my affidavit on April 2024. I filed my affidavit. Lordship. We have filed an affidavit. Lordship. We have filed an affidavit. I filed it. The month of April. Lordship.
You have filed an affidavit on 23rd of April.
Yes, Lordship. I inadvertently, I did not put the date in my affidavit.
23rd of April.
Yes, Lordship.
ROP release.
Yes, our release. Now there we have got to the other district. So in paragraph number 3, Lordship, we have taken up the other two districts, Long Leng and Noklak. These are the interior part of the Nagaland Lordship. So we are giving priority to the remote areas.
Understood. It is the central government scheme out there. The central government is ready to spend the money.
Lordship.
But why you are only going into that
No,
pilot
Lordship.
project?
In the other PIL Lordship,
Ah,
we have trained the staff's Lordship. Lordship in PIL number
Mr.
15.
Yangwati, you have filed an affidavit.
Yes, in item
When did you file? 27th of February 2004, 24? Released by 123. In which matter did you file?
in BIL 15.
Hmm?
BIL 15.
15.
Item
Oh,
40.
15. There's another PL. Health and family welfare. That's of 7th of December.
Yes,
For that, we have duly taken note of earlier. In fact, if you see our order, which was passed on, this is a detailed order being passed on 28/2/2024. Madam, you have that order?
Yes, Your Lordship.
So there we have categorically dealt with his affidavit also, wherein various amounts have been given. Also finds it very pertinent to take note of the implementation guidelines of AI enclosed to the said affidavit, which stipulates as to how the implementation of the said scheme is required to be made. It is stated that the focus should be on the strengthening of the adolescent-friendly health clinics at the level of district hospitals and community health area with physical makeover to ensure privacy and so and so. Have you done anything?
Yes, Lordship. In
Only
my
for Kifri?
Lordship, in
Nothing else.
PL number
You can't
15,
do that.
PL number 15, Lordship.
Whatever. we-
Regard to adolescent-friendly health clinic.
No, only for Kifri, not for others.
No, for others we have set up. In PL number 15. There's another PL, number 15.
Yes, where? You have filed an affidavit.
Yes, Lordship. Lordship,
When?
kindly come to page, this was filed in 2021,
Huh?
3rd of March,
2021,
21. Yes.
9th of March.
It was signed on 9th, 3rd and filed on 9th, yes.
Yes,
Lordship, may I kindly come to
adolescent-friendly
page-
health clinics in the districts.
Yes. The chart is at page 4. Lordship.
Hmm. Then you have done this.
Yes, Lordship.
But what are you doing in Kifri then?
Lordship, as far as the RKSK scheme with the distribution of the napkin, sanitary napkin for the adolescent girls, Lordship. We have started in Kifri, Lordship, and we have extended to Noklak and Longlang district, which will be covering, Lordship.
And are you also taking up the steps again in the schools?
Lordship, as per the scheme, Lordship, as per the scheme, we are going by the guidelines, Lordship.
No, the guidelines only say, kindly do it in the schools. Makes it clear. That is what we recorded in the last order.
Yes, Lordship.
Categorically says 7th of December, the guidelines see read it out. It should be in the schools primarily, because there you have the maximum number of adolescents. Where is that, madam?
Lordship, also in the affidavit filed by the central government, Lordship,
Yes.
they have enclosed a guideline which clearly states that it has to be in the schools and on the hospitals, Lordship. Hospitals, Lordships.
Page
Starting from page 16 of the affidavit filed by the central government, Lordship.
15.
16, Lordship, page.
16. Yes, structure, district hospital, community primary. Yes, here it will be somewhere in the schools. I've read it somewhere. Centers of the environment. The importance is to be given in the school. Somewhere it is given. This one, 17, down below. School-based approach. What have you done with that? And this is the basis on which I've asked you to file an affidavit. No affidavit has been filed. You have come up with this ROP release and all. We are not concerned. have you done it? And my order, our order on this date was very clear, 28/2/2024,
28
paragraph
to
7,
28 to 2024.
paragraph 7 of the order.
That's the instruction received. I have filed. But apparently that school-based programs, Lordship.
That is what it is. It categorically mentions that it should be school-based.
As per the
School-based
instru-
approach, because
as-
you find the maximum the adolescent there. And how do you expect these young small girls to go anywhere? How will they go to these clinics?
Lordship,
Somebody has to take in.
As per the court order, Lordship, I've already intimated the department, but this is the only instruction I've received, Lordship. So if I may be given some
Then you
time,
have to also ask the department that look here, we have asked you something, you have given, I've asked you A, you have given me Z. Z would not work.
Lordship, sometime may be granted, Lordship. I'll get the information. I'll find it. With regard to the paragraph 7, Lordship.
When this type of PL should finish, we are 5 years down the line with these PLs.
Lordship, another aspect
And
of
you are
matter-
still on the pilot. It is no longer a pilot is for a month, pilot is for 3 months. We are 5 months, 5 years.
Lordship, one of the challenges faced, we have filed in the earlier PIL also.
Because the most pertinent aspect to the matter is the money is being given by the central government.
That is the issue, Lordship. What we are saying in our affidavit in the other PIL, though we have not categorically stated here, the fund release. We project our budget as per the requirement of the state. Sanction is there, 100% sanction. But ROP release is always in installment and we don't get the full amount. We have stated in the RPIL also. That's one of the challenges faced by us. And even in the affidavit in PL number 15, we have stated the challenges.
You say, then you come up with a specific affidavit, say that the central government has come up with all these schemes, but that is only just for the purpose of showing it to the people.
Page-
But actually they are not paying in a single penny. Put it there, we take it up with the central government. then.
Page 4 in the PL 15.
Hmm?
Page 4 in the PL 15.
Of page 4 of the affidavit.
Yes.
Yes, what do you say?
Under the financial issues, Lordship, the challenges that we are facing. But whatever resources that we have with us, Lordship, we are doing it.
No, what do you say at paragraph number Roman 3, the clause number Roman 3, page 6? You don't say anything against the state government, central government. You say this fund sanctions through the state treasury route, the process of fund transfer from the state government through where takes more time. Often the fund is received at the
Lordship, we
end of
can-
the financial year or later. Furthermore, though the department is well aware that much is required to be undertaken to move ahead with so-and-so or the pragmatic
No.
goals, the resources made available by the government is also not sufficient to fully implement all the approved activities.
Now, coming to my affidavit,
This you can't make it like this.
Yes.
Why you have not been, you have to give more details.
Lordship,
Because they categorically say in the affidavit that look here, we are giving everything. They are not doing
I
it.
have shown in the 23rd April affidavit in PIL number 23. I've given the chart how we are running short of the fund.
PL number on 27th of February.
Filed on 23rd of April 2024. The chart that I've
Annexure
enclosed.
A.
Annexure B, Lordship, page 4.
The annexure A is there. Or this- Oh, ROP.
You can come to the chart.
Annexure B.
For 2021 Lordship, total approval approved under NHM 198 CR. Resource envelope 161. GI sanction 80.31, stature 10 point, this is 90-10 project lordship. So we received 91.16 out of the 198.
And you spend only 30.62.
Lordship,
You have got the amount of 92.05 and you spend only 30. So you don't give the utilization certificate. Why will the union pay?
Lordship, we spent 30.
Page 5?
Page 5.
Amount approved 92.05, expenditure 30.62. So you are not giving your utilization. Why will the central government pay? Everything has to be given utilization. Don't help it like this. Funds received during financial year. Difference. Government of India is paying, you are not utilizing. What to do?
Lordship, I'll bring to the notice of the expenditure, Lordship, because it does not only include the procurement of the napkins, Lordship, even the salary components are there of the staffs. So, Lordship, if I
From the
may be given-
materials on record, it does not seem that the state health mission have, that is the respondent number 4, had filed an affidavit in consonance with the directions so passed by this court on 28/2/2024. More so, more so in view of the fact that there is no mention in the affidavit as regards implementation of the Rashtriya Kishore Swasthya Karikram (RKSK) with a school-based approach,
Lordship.
which is mandated in the guidelines. More particularly, at page 17 of the affidavit filed by the union on 7/12/2023.
Lordship.
Mr. N. Mujoy, the learned counsel appearing on behalf of the State Health Mission submits that he requires
Lordship, 3 weeks. Lordship.
3 weeks' time for filing the affidavit in consonance with the directions passed by this court on 28/2/2024.
Lordship.
Taking into account the above, this the matter on 3rd of July 2024.
Lordship.
Obliged, Lordship. My apology, Lordship, that was overlooked, Lordship.
For admission, item number 41.
My pleasure. Worship, I have not received any instructions so far. This case.
Huh?
I have not received any instruction.
Yes, madam, did you file the affidavit in pursuance to the order dated 28/2/2024? Yes, yes, I've
Lordship,
seen it. 15/5. Okay. Let us see what do you say.
So your lordship, from page 9, these are the money received from the union and the utilization. Your lordship.
But if I remember correctly,
Yes, lordship.
the photograph
Yes, yes.
last time when I
Yes.
saw
Yes.
was in a very pathetic state of
Lordship,
affairs.
so your lordship, last year, we, in the month of
If you are getting
December.
so much of financial outlay, why the photographs are in such a sorry state of affairs? Where are the photographs? Very sorry state of affairs. That is why I put you to file an affidavit what you are doing with that money. Where is that photographs, madam?
Lordship, the letter status which I
got
filed.
it, got it, got it.
Yes.
It is here. Mon, yes. It is to your PIL, no? No, the affidavit, yes. We are getting so much of money, why the
So your lordship,
state of affairs is such?
lordship, last year in the
See
month
the
of,
school,
yes.
GML, Mon, County, and you say that you are getting finance, you are making what? Let us see what you are doing. Boundary wall, 40 lakhs. 4 lakhs, 40,000. 40,000. How much amount you have got?
Yes, your lordship. 40,000, your lordship.
What is this vending machine and incinerators? What are those? Vending machine for what? Coffee? Library. How much amount you have got for library?
For library, your lordship,
Oh,
9,460.
9,000.
In 2021, yes.
Bench and desk, 27, 3 lakhs 48. School ground, elementary. BPS free uniform. Additional financial demand in lakhs. Yes, madam, what do you say about these?
No, Lordship, I received a copy yesterday and I priced the
Oh,
petitioners.
Lordship,
Lordship.
I've informed her, but she's not around in the court. She
She's
received-
she's only available on Wednesday.
Lordship, I received instruction for the petitioners that since there a lot of development is showing in the affidavit file, so they want to verify, so some time may be given, Lordship.
Okay, let's find out. Yes. Miss so-and-so, the learned counsel appearing on behalf of the petitioner submits that she has only received the affidavit filed by the respondent number 2 to 6 in pursuance to the order passed by this court on 28/2/2024, only yesterday. And as such, she needs to take instructions as to whether in the materials, whether the materials, whether the contents of the enclosures are in accordance with the, and she would like to take instructions as regards the activities or the expenditures which have been shown in the enclosure to the said affidavit. She therefore submits that she requires 3 weeks' time for doing that.
Yes, Your Lordship.
List the matter on 10th of April, 10th of July.
Yes, Your Lordship.
On that day, on which date the learned, the counsel appearing on behalf of the petitioner shall shall after completion of necessary verification file an affidavit if there is any deficiency to what have been stated in the said affidavit filed by respondent number 226.
Obliged, Your Lordship.
For admission, item numbers 42 and 43.
May I please, Your Lordship. Lordship, IA 23 is for condonation of delay, Your Lordship.
Hmm?
IA 23.
Delay?
Yes, Your Lordship.
How much?
37 days, Your Lordship.
Other side appearing?
Yes, Your
You
Lordship.
there?
Yes, Your Lordship.
How many others are there?
Only me, Your Lordship, the sole respondent. But Your Lordship, item number 42, 43, and 44. The writ appeal arose out of a common judgment and order against 4 writ petitions, Your Lordship.
Against?
4 writ petitions.
Ah.
So they have filed only 3 writ appeals initially. And then after a delay of about 1 month, they have filed the 4th writ appeal.
This one?
Yeah, no, it's not listed today. So it has to be clubbed along with that writ appeal.
No, first let us delay, condone the delay.
Delay, though, I have no problem with those, Your Lord.
This is an application. Filed for condoning the delay of 37 days in preferring the appeal, accompanying appeal against the judgment and order dated 22/12/2023 passed by the learned single judge in WPC number 133/2020. Other appeals have been already there, filed. There is no delay.
No, there is delay in all the 4 writ appeals. There is delay, continuation,
No,
application, and
Is
all.
there any delay in those appeals?
Yes, Your Lordship.
Yes.
Is there other matters are here today?
It
Yes,
is not
3
listed.
3 is listed, and 1 is not listed, Your Lordship.
Yes, Your Lordship.
Okay. It has been stated in the said application that the applicants had no notice of the delivery of the judgment passed by the learned single judge. In as much as the hearing was concluded on 29/2022 and the judgment was pronounced in the principal seat on 22/12/2023. And at that relevant point of time, the Kohima bench of the Gauhati High Court was on vacation. In the opinion of this court, the ground which have been mentioned in the application constitutes a sufficient cause within the meaning of section 5 of the sufficient cause for condoning the delay of 37 days in preferring the instant appeal. Accordingly, the instant application stands allowed by condoning the delay of 37 days. What is our next IA for?
Lordship, this IA is an application to place in record certain developments subsequent to the.
Subsequent development,
Yes, your lordship.
we'll look into that. First, writ appeal, we'll take it up on some other day.
Lordship.
You are not ready today, I suppose. You ready?
My senior will be arguing this case. Your lordship.
Just taking into account that the delay has been condoned today, the councils expresses that the matter be taken up for admission on some other date. Accordingly, when?
Any date, your lordship.
After 2 weeks, your lordship.
Yes. Accordingly, list the matter on 19th of June, 2024.
Your lordship, and then this writ appeals may be clubbed along with writ appeal number 14 of 2024.
That is not before me. There is a delay condonation, na?
Yes, your lordship.
Yes, your lordship.
It will writ appeal
Otherwise, it's a
not
same
already.
common judgment and order.
So they can- Let it be there.
Much obliged.
Lordship, item number 43, lordship. There was also delay, lordship. 44.
what?
lordship. IA 25.
42 and 43.
Okay, so item 44. IA 25 of 24.
What is this?
37 days delay.
There is a different appeal.
Yes, your lordship.
Where is 43? That is the delay application. We have disposed it of IA 23. We have disposed of this, and this we have passed an order. And this the 46/2024, we have passed an order fixing it on 11th. Then. Son.
For admission, item numbers 44 and 45.
Oh, same,
Yes, your lordship.
same
They also
delay.
delay of 37 days.
37 days, the same order. This I disposed, 25 disposed, Baki 10th of. When did I fix? 10th of, 17th of, when did I fix?
Can we fix on the same day, your lordship?
19th, huh?
Yes, your
Yes, 19th of June.
Much obliged.
For orders, item number 46.
May I please, Lordship?
Yes.
In this case, we have received the paper book. Lordship,
So
the
we
case
fix
is
it
ready
for
for
hearing?
hearing now.
Paper book ready?
Yes, please.
We fix it for hearing?
Yes, Lordship.
Okay. Taking into account that the paper book has already been prepared. List the matter for hearing when?
After 3 weeks, lordship. After 3 weeks.
2 weeks.
3 weeks. 3 weeks.
Be listed for hearing on 19th of June, 2024. Yes, Mr. Chaudhary. What?
Small prayer is also recommended me.
Yes,
There are two matters above us. Ours is item 49.
okay.
And I have taken consent of my learned friend.
Uh-huh.
So Lordship to kindly take up our matter, my lord, to go back.
49,
49.
writ appeal.
Yes,
Okay. You don't want to do it today?
I want to do it, my lord. Since I have come, can I start now so that? Or
Can we do it at 2? No. Or you want to do it some other day?
now it is already 1 o'clock.
Yes. So that is what. We have to do it at only at 2. You want to do it. Or you want to do it some other day? What is the matter about?
My lord, it's a matter related, eventually now it boils down to fixation of seniority. We're assailing the, initial contractual appointment followed by regularization of the respondents.
Okay.
That is the point.
The contractual appointment.
Contractual appointment followed by regularization.
So would they be given seniority from the date of the initial appointment?
Yes.
Can it be? I don't think so.
My lord,
Is
it
it
can't be, it can't be.
The direct recruit, they would not help.
There is a set of rule. The department has, Lordship would know, in 1986, Government of India issued a memorandum whereby it was said that they will form part of the cadre of the service. Therefore, states were directed to frame rules, and the 309 rules are there. And there is no provision of regularization. In the rules, either it can be by direct recruitment or by promotion. We are all selected by the Nagaland Public Service Commission. We entered, of course, we entered the service in class 3 initially, then we are upgraded, then promoted. Now we are in the same cadre. Now therefore, the dispute is with regard to seniority.
No, Your Lordship, dispute is not with regard to seniority.
No,
Seniority
now
has
it
nothing
boils
to do
down.
with it in this case.
Now it boils down.
There is no question of seniority.
Okay, tell me, if you want to do it, do it. If you don't want to do it, take your, enjoy the lovely weather and go. I leave it to you, the.
Ah, that is there. Well, some other day.
Some other day.
Yes. Because I have to get back because tomorrow some matters are there I have to reach. In any case, even if I go now, I'll reach at 10, 11 now.
This road has become bad.
Yes.
And in the evening, going out there, nowadays you never know with the landslides
Right,
happening
right.
out there. Okay. Mr. At the request of the parties, the matter stands adjourned to when?
After the summer vacations.
There is no summer vacation here.
Let it be in this second week of July.
Again on 10th of July.
One second. Let it be on 5th now.
24th.
Oh, Wednesday, 24th.
24th of July.
Yes.
This is the matter again on 24th of July 2020. At the request of the parties, the matter stands adjourned to be listed again on 24th of July 2024.
Your Lordships, I would like to mention item 50, next item. Can be posted after 2 weeks.
Anyways, Mr. Siti Jamir is not there, na?
I'm just also.
Oh no, Siti Jamir is here. He was very much there. Okay. Mr. R. Iralu, the Learned Senior Counsel, submits that he has some inconvenience today, and accordingly the matter stands adjourned to be listed again on 19th.
19 just before 2 read appeals have been fixed, Your Lordship. 2 read appeals have been fixed.
2 weeks is 19. Today it's first week gone. Second week, the 2 weeks is completed on 19th.
Yeah, otherwise, Your Lordship, the item number 42 and 43 has been fixed on 19th.
So,
read appeal, item 42 and 43. So there will be difficulty taking up all those matters.
26th?
Yes, Your Lordship.
Obliged.
26th of June.
Much obliged.
Matter finished. Any more?
There are 2 more.
Which one?
2 more.
Order item is there, na? 46. 56 is there, 52 is there. Huh? 47 and 51. 47 and 51. Okay. Hello, we'll come back again at 2. And we could have finished. Are the councils ready to do those 2 matters? Anybody? 47 and 52.
Yes, 47 we are ready, Lordship.
You are ready?
Yes, Your Lordship. Yes, Your Lordship.
You are ready?
Yes.
Then we will come back.
disposed.
47.
47, I beg your pardon.
Yes, 47 will be doing. You have not filed a reply affidavit?
Lordship, for that, Lordship, I will be allowed to produce some reports, Lordship. Lordship, the allegation made in the PIL is that we are not implementing the C program, National Viral Hepatitis program. Now, Lordship, we are stating that after that we are fully implementing the program. Now, the document that I would like to show, Lordship, the petitioner, NGO, they are receiving money from us to promote. Two, Lordship. The president, ARK Foundation, the petitioner, ARK Foundation. So they have been assigned with the awareness in 4 districts, which they have already carried out.
Lordships, we have no issue with that. In fact, much development has taken place after the filing this petition, Lordship. Now, prior to the filing of this, the issue raised, this petition was filed in the year 2018, Lordship. 2018, Lordship. It's a long time back.
Nothing remains now.
Lordship, there has been a lot of development has taken place with the intervention of this court, Lordship. Now,
It is a matter about, let's see.
In the affidavit filed by us as a Lordship, we have given a detailed explanation of as to how the program has been implemented the state.
What is HCV?
hepatitis C,
virus.
Lordship. Yes, viral hepatitis C.
Which 4 and 5?
I'm for the response. We have filed affidavit. Go to the steps that we have taken, Lordship. Can you come to page 9 of my affidavit?
The affidavit dated 14th of March 2022.
Yes, Lordship. Paragraph, page 9, clause B, Lordship. National Viral Hepatitis Control Program in the state of Nagaland. We have launched in 2018. And since 18, the steps that we have taken, Lordship. Lordship has come. Page 9. As far as the activities of the state is concerned, Lordship, we are explaining.
What is not NHK?
Naga Hospital Authority. Kohima. But before it was a district hospital. Now it has been declared as an autonomous authority. The next page, Justification, the target for 2024. We have even set a target for 2024.
Is it the unions? Have you filed a reply to this affidavit?
I have filed one reply, Lordship, but I don't know which affidavit. Lordship, if you would kindly,
You file a reply.
I filed one reply on 29/6/2022, Lordship. To the state affidavit, Lordship, reply to the state affidavit. Now, Lordship, we have, allow me to cite the case in a brief, Lordship. The inception of how, in fact, the same issue was raised in the year 2008, Lordship, in the form of PIL number 2, 2008, Lordship, in which the matter was disposed of by an order dated 5th August 2011 by the then Honorable Chief Justice, former Chief Justice of India, Madan Lucy Locker, who was then the Chief Justice of Gauhati High Court, Lordship. Direction was given. Since during that time, there was no program, Lordship, for implementation of our.
Okay, I have looked into the affidavit.
Yes.
And your reply, you say that in these cases, they do the fee. Yes. You must do most of them.
Lordship, yes, Lordship. Now the issue is that only now, Lordship.
No, they say that they do for fee services.
No, as far as baseline investigation is concerned, Lordship, they said in the affidavit that, Lordship, allow me to kindly take you to the state's affidavit, Lordship. To the affidavit filed by the state.
No, direct them to do the fee services.
Yes, Lordship, as per the program, Lordship, as per the program,
Well,
Lordship.
again, we should
Then-
not further, you see, otherwise. Yeah, so I don't.
Yes, Lordship.
I will use the PI because you see. the
Lordship,
person-
yes.
Because what otherwise shows is, each person concerned. File the PI. And knowing fully well, if there are directions for publication, he will take the benefit of financial gain.
Yes, Lordship.
You have nothing
No,
to
no.
do, I'm not saying anything about you. He has taken the benefit that you have a good reputation in filing, and he has taken the benefit of that.
Lordship,
Let us not deal with that.
Lordship, I think there's a misunderstanding. These are health activists, Lordship, who help the state government, Lordship, in fact, In fact, it is the state government who also consults with them. We have the HIV and AIDS Act. That also, their involvement is there in framing the act itself. They are health activists at the national, international, and at the state level, Lordship. So it's not about soliciting, Lordship, but the funds that they receive, it is not in my knowledge, Lordship, but then there's no illegality because the state government
madam. I
used
tell-
your
tell
service,
you- I
Lordship.
tell you why. You have, on one hand, you have filed the instant petition
Lordship.
asking that the state government or these authorities should publicize the aspect about its hepatitis C, all these benefits are given.
Lordship, yes.
That's your third prayer. If that be so, and this person very well gets the benefit when the this is to be given, publicity is to be given, because he does the publication on behalf of them.
This is the development, Lordship. These are the development.
So let us not go into that.
Yes, Lordship.
We dispose of the petition
With the
only
direction.
what they say, and you say that this is not there, so we direct them.
Yes.
If they have not done it, they shall.
Yes, your
I
Lordship.
think that
Yes,
is
your
the-
Lordship.
That is it.
Yes. Yes.
The instant public interest litigation is filed to bring to the notice of this court that adequate steps have not been taken by the respondent authorities in tackling the prevailing status of hepatitis C virus, bracket HCV, in the state of Nagaland, semicolon, to ensure the testing and treatment of HCV, bracket, including essential diagnostics and medications, etc. Medication, that is BAA, all caps, SC smalls, comma, confirmation of chronic HCV with viral load testing, comma, etc. is provided free of cost in the state of Nagaland and any accredited hospitals, semicolon, to identify and adequately publicize the names of the hospitals, comma, laboratories, comma, medical stores, or any other relevant medical establishment which could provide testing and treatment of HCV, bracket, including essential diagnostics and medications, bracket close, free of cost in the state of Nagaland, semicolon, to ensure that the primary health center and the community health center are adequately equipped and authorized for HCV antibody testing, semicolon, testing, comma, testing comma, and referral to public hospitals for further treatment, semicolon, to include all drugs for treatment of HCV under the essential drug list of the state, etc. Pursuant to the filing of the instant public interest litigation, this court in the year 2018, this court issued notice to the respondents the respondent number 4 and 5 have filed a detailed affidavit narrating in brief the National Viral Hepatitis Control Program bracket NVHCP bracket close, and the implementation of NHVCP in the state of Nagaland and the challenges faced during the process of implementation. It has been stated in the said affidavit that the government of India had decided to launch the NVHCP for prevention and control of viral hepatitis with a view to provide free of charge screening, diagnosis, treatment and counseling services to all, and especially to people belonging to HRGs. What is it? Bracket high risk group. It was also mentioned that this NVHCP was implemented with the aim of combating hepatitis and achieve countrywide elimination of hepatitis C by 2030, semicolon, achieve significant reduction in infected population, morbidity and mortality associated with hepatitis B and C, viz. Cirrhosis and hepatocellular carcinoma, is by enhancing community awareness on hepatitis and lay stress on preventive measures among general population, especially high risk groups and in hotspots, semicolon, provide early diagnosis and management of viral hepatitis at all levels of healthcare, semicolon, develop standard diagnostics and treatment protocols for management of viral hepatitis and its complications, semicolon, strengthen the existing infrastructure facilities, capacity building of existing human resource and raise additional human resources, where required, providing comprehensive services for management of viral hepatitis and its complications in all districts of the country, semicolon, develop linkage with the existing national programs towards awareness, prevention, diagnosis and treatment for viral hepatitis, and to develop a web-based, inverted comma, viral hepatitis information and management system, inverted comma close, to maintain a registry of persons affected with viral hepatitis and its sequelae. It has also been mentioned that the said NVHCP has various facets or for that matter, components. First is the preventive component, which includes awareness generation, immunization of hepatitis B, comma, safety of blood and blood products, comma, injection safety, comma, safe socio-cultural practices, and safe drinking water, hygiene, and sanitary toilets. The second component is diagnosis and treatment, which includes screening of pregnant women for HB, all caps, HB, small s, A capital G, to be done in areas where institutional deliveries are less than 80% to ensure their referral for institutional delivery for birth dose hepatitis B vaccination, comma, semicolon, pre-screening, diagnosis and treatment for both hepatitis B and C to be made available at the levels of healthcare in a phased manner, semicolon, provision of linkage, including with private sector and not-for-profit institution for diagnosis and treatment, and engagement with the community of peer support to enhance and ensure adherence to treatment and demand generation. The third component is monitoring and evaluation, comma, surveillance and research. The fourth component is training and capacity building. It is further seen and filed by the respondent number 4 and 5 that the NVHCP program was launched in the state of Nagaland in the year 2018, or for that matter, during the period when the instant public interest litigation was filed. There is a state reference laboratory set up at the Naga Hospital Authority, Kohima, wherein there is also a model treatment center. It has also been mentioned that there are treatment centers at Dimapur, Mokuksong, Hwansong, Junaboto, Mon, Longleng, Kifri, Fek, and Ferren. It has also been mentioned that viral load testing kits are available in all the above mentioned testing centers. The respondent number 4 and 5 have also stated in their affidavit as to the profiling done in respect to hepatitis B and hepatitis C in the state of Nagaland during the period from 2019 to December 2021. Further to that, what the state respondents targets to do for the period from 2022 to 2024 have also been mentioned. It has also been mentioned that there are various challenges faced during the process of implementation of the program. However, Mr. Mojoi, the learned counsel appearing on behalf of the state respondent, submits that there were initially certain hitches which have now been streamlined. He, however, submits that in cases where the deliveries, the childbirth takes place outside the institution, the benefits of the NVHCP program are not being availed by such mothers. It has been categorically stated that these services which are given are free services offered by the government to safeguard the HCV from hepatitis B infection, at the healthcare settings. The manner in which it has been implemented have also been mentioned in the said affidavit. It has been stated that the NVHCP is a vertical program under the umbrella of National Health Mission. It is a part of the National Health Mission Program Implementation Plan. It has been specifically mentioned that all drugs related to treatment of HBV and HCV are received in kind from the ministry, which are given free of cost to the patients. Further to that, it has also been mentioned that the testing kits and the laboratory consumables for HBV and HCV are supplied free of cost to districts for patients. This court also finds relevant to take note of an affidavit in reply filed by the petitioners to the affidavit in opposition filed by the respondent number 4 and 5. In the same affidavit in opposition, affidavit in reply, it has been mentioned that as far as screening oblique testing is concerned, most of the cases in Kohima, the ARC Foundation does the screening and referring patient to NHAK for conformity test. It has also been categorically mentioned that apart from free screening and conformity tests, the model treatment centers in NAK and treatment centers at Dimapur, Mokokchung, Tuansang, Junabetu, Mon, Longling, Tifre, FEC, and Ferin does not provide free services for testing like complete blood count, liver function test, kidney function test, etc., which mounts up the expenses of poor patients. It has also been mentioned that the model treatment centers opens only twice a week and therefore it is inconvenient for the patients. This court further finds it relevant to take note of an affidavit in reply filed by the respondent number 6. This affidavit is relevant taking into account that the said affidavit has been filed by the Union of India, who is actually sponsoring the entire scheme. It has been mentioned in the said program that in the said affidavit that the technical and financial support under the National Health Mission is provided to the states oblique the UTs based on requirement proposed in the program implementation plans submitted by them. For the state of Nagaland, the central share is 90% and the state share is 10% of the total funding. It was further mentioned that the NVHCP was launched in India on 28th of July 2018 under the aegis of the National Health Mission in alignment with the Sustainable Development Goal Target 3.3. The program emphasizes prevention through awareness generation and management of viral hepatitis by provisioning free diagnosis and treatment. The program aims to achieve elimination of hepatitis C by 2030, semicolon, achieve significant reduction in the infected population, comma, morbidity and mortality associated with hepatitis B and C, namely cirrhosis and hepatocellular carcinoma, bracket liver cancer, semicolon, reduce the risk, morbidity and mortality due to hepatitis A and E. It has been mentioned that the state of Nagaland had proposed implementation of this program for addressing the viral hepatitis disease burden since 2019. In that regard, it has referred to an enclosure which have been enclosed as an A, which is the document, which is the NHM record of proceedings for 2019-20 of the state of Nagaland. Annexure 1, which is the NHM record of proceedings for 2019-20, 2020-21, 2021-22, and 2021-22. From a perusal of the said annexure, Roman 1, it is seen that various amounts have been released to the state of Nagaland. Oh, 2020. 2021, 22, and 2020 and 2022, 23. 2022, 23, and 2023, 24. Annexure Roman 2 of the said affidavit is of vital significance inasmuch as the Joint Secretary to the Government of India, Ministry of Health and Family Welfare, have issued directions to all the mission directors, state mission directors of the state health missions, stating that the NVHCP have been rolled out for diagnosis, treatment, and management of viral hepatitis. And under the program, free drugs and diagnostics are being provided to all those in need. It has also been mentioned that testing kits for serology, ELISA, rapid test kits for hepatitis B and hepatitis C have been procured centrally and provided to the states. However, on account of COVID-19 pandemic and on account thereof, and on account of the disruption in the supply chain, the states, union territories were directed to procure the said testing kits for serology from the existing cash grant or with minimum reappropriation funds as per the PIP of the current year. In addition to that, it is also seen from the affidavit. That although the central government provides 90% of the funding, but taking into consideration entry 6 of list 2 of the 7th schedule to the constitution, the implementation of the program is the responsibility of the state government. This court have duly heard the learned counsels appearing on behalf of the petitioners. And it has been brought to the attention of this court that since the filing of the instant public interest litigation, there has been various steps being taken for providing the benefits in terms with the NVHCP. It has also been submitted that the SEED scheme, the program, is presently fully operationalized in the state of Nagaland. And free treatment have been duly provided. However, the learned counsel appearing on behalf of the public interest, appearing on behalf of the petitioner submits that to our information at the time of filing the affidavit in reply, the model treatment centers does not provide free service for testing like complete blood count, liver function test, and kidney function test, etc., which mounts up the expenses of the poor patients.
Lordship, it includes
In the treatment
Dimapur, Mokokchung,
Model
Changsang.
training, model treatment center is NHK. We are providing. The allegation is in the treatment center.
Lordship, if you see my affidavit, even in the model treatment center, it is not provided. Yes, we have clearly mentioned that for confirmatory tests and screening tests of viral hepatitis, it is provided. But then before doing that, Lordship, the patient have to come for treatment and have to come for further review, Lordship. During such time, they are made to, as per the requirement, the doctors prescribe them to go for screening tests again, Lordship, to see whether their
You need to file another PL against those doctors.
Lordship. No, it is very
This is
simple
an
because
everyday issue.
the guideline is very clear that it has
That
to
day, in
be
fact,
screening test should also be
That
free, Lordship.
day, just out the way, I went to a doctor. So I told him that I'm having a frozen shoulder. I have a pain also. So the doctor said that, asked me immediately, okay, you go and do that particular, what you call, MRI. And- No, in Gauhati. And I have a big problem with that MRI because you have to go inside the machine and I get there, claustrophobic. I said, no, nothing. I went to another doctor. I said that, you see, this is the pain I'm having, but I'm not going to go for an MRI. It's no, it's a frozen shoulder, so you can do it for body, you don't need for going for it. But it's the fact that you said that you are a judge, no doctor would otherwise take a risk out there. And as such, he must have said that you have to go for an So this is, so that you are, what to do with the doctors?
Lordship, it is in a treatment center, Lordship. So our prayer is that although we are,
You see, what is required for the hepatitis for the purpose of uh, finding out what is required for the purpose of pre-diagnostic or diagnostic.
yes, Lordship.
What
They
is
call it clinical
required for
investigation.
pre-screening, they will do.
Yes, so those are not being covered. Those are not being covered by this, by the treatment centers as well as model treatment center at currently, Lordship. That's why our request is if this can also be given free of cost, because the
Now, this
guidelines
will be
says
provided if it is given, but do they have any connection
it
with
is
that?
attached with the hospital itself. All the model treatment centers and the treatment centers are attached with the hospital, Lordship, with the government hospital, Lordship.
Understood, then you have to go for Ayushman Bharat with another one.
Ayushman
That
Bharat,
is, Ayushman Bharat will take care of that.
Ayushman Bharat does not cover, Lordship. It only covers inpatient, Lordship. You have to be hospitalized. You have to be hospitalized. That too in the general ward of the hospital.
Beyond that, Ayushman Bharat, the state is a treatment center where even public, actually the scheme was introduced for pensioners and but now that has been extended.
No, only thing is, if these testing of blood, complete blood count and liver function and kidney test are etc. are required in connection with the hepatitis B or C,
Both,
then we have
Lordship.
to do it.
Both, Lordship.
But if it is not,
As per the guideline, Lordship, yes.
Even the
Then
guideline
Because
says,
those are very.
if the guidelines say very well,
yes, guideline
So
says it
Lordship,
has to
if the
be.
observation may be made that if the guideline provides, then we may be directed to give. Because we have to go by the guideline.
Because
as
these
was
are all
already
connected with the
right last
treatment.
time, I submitted that so and so have not been done, no? Submitted that, apart from free screening and conformity test, the model here, centers in NAC and treatment centers at so and so does not provide free service for testing like blood, complete blood count, liver function test, kidney function test, etc., which mounts up the expenses of the poor patients. It has also been alleged by the learned counsel appearing on behalf of the petitioner that at that relevant point of time, the MTCs, the model treatment center, used to open twice a week, and it was therefore inconvenient for the patients.
Lordship.
On the other hand, Mr. N. Muzal submits that the that all testings which are required for diagnosis and treatment semicolon, diagnosis and treatment coming within the ambit of the NVHCP. Now, diagnosis of treatment of hepatitis E and hepatitis C would fall within the ambit of the NVHCP. If further submits that if upon diagnosis there is a requirement that the complete blood count, liver function test, kidney function test, etc., are required to be made having relation with hepatitis having relation with the hepatitis B and C, or for that matter, the program of NVHCP, the model, the NAC, as well as the model treatment centers would duly provide the safe testing services. However, if it has no connection with the treatment of hepatitis B or C, with the connection with the prevention and diagnosis of hepatitis B or hepatitis C, the scheme would not provide such benefits. Isn't that your scheme, Mr. Murali? That is your submission.
Yes.
If it is
Because
provides out
we
there.
have to go by the guideline.
Ah.
I've mentioned in page 8
Of?
of my affidavit. As far as the treatment is concerned, so we go by the operational guideline 2018, page 50 of the guideline.
Page 10.
Page 8 of my affidavit. Bottom lordship is found in the bracket lordship. National Viral Hepatitis Control Program, operational guideline 2018, page 18, the treatment mode. How it is done. So we have to go by the guideline.
He further referred to where page 50 of what? Where is the guideline? It must be here somewhere. Of
Affidavit of the affidavit in reply of the petitioner.
where? Where is it?
Lordship, if I may
Yes,
assist.
it's where?
Lordship, in page number 25, it is mentioned, Lordship, the last paragraph, Lordship. The government of India has hence decided to launch a new viral hepatitis control program for prevention and control of viral hepatitis with a view to provide free of charge screening, diagnosis, treatment and counseling
That
services
is
to all.
okay. That
And
is okay. That I
yes,
have
Lordship.
already mentioned.
And
But where
also-
is it? What are the things?
And also, yes, Lordship, the detailed guideline. What the model treatment centers should give, provide is in page number 45.
No,
Lordship.
this, you see, kindly come to page 27, the components, diagnosis and treatment. Free screening, diagnosis and treatment for both hepatitis B and C would be made available at all levels of healthcare in phased manner.
Yes, Lordship.
So they will provide, which has any connection with hepatitis B and C.
Yes.
That is what I'm
Lordship,
saying.
if that observation is made in the order.
No, that is what I'm going to say.
Yes, thank you.
I'm saying, going to say that this is the feed which has to be made. There cannot be any charge being levied on that.
Lordship.
But if it has no connection with the blood, just for example, today I want to go get my blood sample out there, I would not be given the benefit.
Yes, Your
It has
Lordship,
to be in connection with.
with the treatment.
We have wrongly quoted the page number, so
Huh?
it's in the diagnosis.
Okay.
In page numbers.
This court, upon hearing the learned counsels, are of the opinion. Are of the opinion that a perusal of the guidelines categorically states that free screening, diagnosis and treatment for both hepatitis B and C would be made available at all levels of healthcare. It is an admitted fact that the that for the purpose of MVHCP, model treatment centers have been set up at Kohima, Dimapur, Mokuksong, Wansang, Junevetu, Mon, Longlang, Kipri, Fek, and Ferin. And as such, if the testing for complete blood count, liver function test, kidney function test, etc., are required having in connection with the screening, diagnosis and treatment for both hepatitis B and C. The said persons, the said patients have to be afforded free testing. Mr. Moses further submits that to his instructions, the model testing centers, testing centers are open
Yes.
throughout the week. Throughout the week at present. Taking into account the statement made by Mr. Mojui, this court also accepts the same and also takes note of, and also taking note of the NVHCP is of the opinion that the said model test centers shall remain open, shall be functional, so that the patients are given are in a position to obtain the necessary facilities as provided as per the NVHCP. Taking into account the above observations and directions, this court finds it and the observations and directions, and also taking into account that the NVHCP is properly functioning, this court finds no ground to further continue with the instant public interest litigation. Accordingly, the instant public interest litigation stands closed. We thank Ms. Suelso, the learned counsel appearing on behalf of the petitioner, for bringing to the attention of this court the said aspect of the above the petition.
Obliged.
For hearing, item number 48.
Anand. Oh, yes,
My
madam.
apologies,
So
Lordship.
that is why I was right in telling you are always available on Wednesday.
Your Lordship, my apologies, I'm appearing in my gown and band, although I'm appearing in person, Lordship.
Just tell me, what is this about?
Lordship, with permission, if you would give me 1 minute, I can remove.
She's appearing in person. Yeah. Can you see the last order? Was on 6/12/2023. Very much was for the Lordship. 6/12/2023.
6/2023. Oh, 6/12.
Yes, we have been directed, Lordship, and come to page.
One thing good, wherever I am there, the orders are more specific. Yeah.
At paragraph 4 of that order, I was directed to file an affidavit with regard to
Now, what is the matter about?
the payment of JSSK. JSSK.
Sometimes we can guess and sometimes.
And 5 of
Mr. Yamadi, you have filed an affidavit. What do you say? Just give me a glimpse of what is the JSSK scheme.
Lordship, this scheme provides free treatment for, this covers newborn and the pregnant woman from the time of pregnancy till the time of giving birth and post few days after the delivery. Lordship, the scheme.
From the time of pregnancy
Pregnancy,
till birth.
yes, till birth, Lordship. And few days after postnatal care, they say, Lordship.
And what is the scheme provides? What are
The
benefits?
scheme says it provides free of cost, Lordship.
What is that
Let me
free of
take you to
cost?
the scheme, Lordship. It starts from page number 39, Lordship.
Page number?
Page number 39, relevant portion is 45. Contents, Lordship.
Down below. High out-of-pocket expenses.
Yes,
for
Lordship.
family.
These are the reason why many pregnant women are deprived and cannot afford treatment, Lordship. This is why central government has taken a very sympathetic view of the poor woman. So the need of having the scheme was introduced.
Entitlement for pregnant women, page 48.
Yes, Lordship.
Free and zero expense delivery and cesarean section, free drugs and consumables, free essential diagnostics, blood, that giving the stay in the health up to 3 days for normal, 7 days for free provision of blood, free transport from home to health center, free transport between facilities in case of referral, drop back from the institution to home after 48 hours, exemption from all kinds of user charges.
Yes, Lordship.
Entitlement to sick newborn in 30 days. Then you're not getting.
Yes, Lordship. What happened is in the year 2017, Lordship, a PIL was moved because this scheme was not effectively being implemented. So this court has passed an order, wide order dated, Lordship, it is in page number 78 onwards, Lordship.
78.
Yes, this court has already passed an order with a direction, Lordship. 78 onwards, Lordship. By order dated 27 May 2019.
The above serial 3 and 4 showed that in the event of pregnancy, Then,
So Lordship,
so
the,
this matter has already been adjudicated.
yes, Lordship, but what happened? After passing the order, Lordship, on 24 June 2019, Lordship, the state government has come up with notification putting a ceiling, Lordship, in the entitlement.
Where?
Lordship is in page number 85, Lordship. 85 and 86.
What is PW? Pregnant women.
Yes, Lordship. So, yes, the entitlement is now
Who pays this money?
central government, Lordship.
Then what is this? The state is doing all these things.
Yes, Lordship.
Why are you doing all these things?
What's the rate?
Who fix? And on one hand, the government categorically say that we are going to give you so much. Where will they get a ultrasound sonography done at 1600 nowadays? Is it possible?
But that is the rate given by the government.
Understood. Normal delivery, drugs and consumables, normal delivery, 60 and rupees 1600 per year. Normally is 350 per pregnant woman for normal delivery. How is it
Lordship.
possible?
And diagnostic, those are ultrasound, rupees 200 only, Lordship.
Diagnosis only 200 rupees. Blood transfusion 300 rupees.
And delivery that is done in the government runs.
Is there-
No, no, Lordship, these schemes covers that the facilities are given at the government hospitals only. So the government hospitals are not giving free of cost, Lordship. That's why I'm here before this court, representing the voice of thousands of poor
Yes,
women,
let's
Lordship.
see what Mr. Yangavati has done. What is the state government doing with 150 rupees more? These people have given 2022, for this happened in 19. They have increased it to 1800. Diagnosis 200 per beneficiary. This is only for indicative where not as a norm. Requirement of funds may vary on the basis of severity complication. The objective is to utilize the allocation in such a way that no out-of-pocket expenditure is incurred by pregnant women and public health institutions. So
This is the rate which our minister is selling to the PIF. The rate. Now, what it was put up to the government, commission, whether we have proposed for enhancement of the rate. Or should we have given a letter on?
no, it's okay. They have given this. They have this affidavit of 2024 makes it clear on 31st of January 2024 of Mr. Yamagati. Is there an answer?
So, Lordship, we vote on 30/5/2020 for enhancement.
Understood, but now they have made it like this. But very relevant is paragraph number 5 of that affidavit.
Yes, Lordship.
How, as per the request made by us, to
Now, enhance the rate, they have already enhanced. That is what they say.
no, that was still not.
When you see this paragraph 4, read it. They already enhanced from 500 to That is why I say, what are you doing? I thought that that was of 2019. Now this is for 2022-24. They've now made it 500, which was earlier 350. And then they have made it 1600, scissoring down, make it 1800. All is done, but the concern out here, I think, paragraph 5 is of great significance.
Lordship, if I may be allowed to slightly correct it, Lordship. This is on dated, Lordship, on wide order dated 6/12/2023. A query was made, a direction was given by this honorable court as specifically dealing with paragraph 6 of the affidavit filed by the central government, which says that the funds being approved under JSSK is based on a unit cost per beneficiary, which has been calculated at the level of GOI, Government of India. However, this is only for indicative purpose and not a norm. States, while dispersing the funds further down, will do it based on similar such calculation and assumptions, and disbursement must be differential for different levels, example, sub-centers and medical colleges. Moreover, this is also to clarify that these funds are flexi funds for carrying out a particular entitlement against which the funds have been sanctioned. So against the query made by the, against the directive on the clarification sought by this court, Lordship, this affidavit was filed. This affidavit was filed, and then Lordship,
I did not receive the recent affidavit. Well, I was not aware, that's why I was putting.
No, it's okay. That is why we directed on 6/12/2023 to file an affidavit. He filed the affidavit. Now, he categorically says that there has been an increase, but the most significant is paragraph 5, where it says,
yes,
it is the others respectfully submitted that the above mentioned is a flexi fund. This is only for indicative purpose
yes,
and not a norm. Requirement of funds may vary on the basis of severity and complications of the case. The objective is to utilize the allocation fund in such a way that no out-of-pocket expenditure is incurred by the pregnant woman at a public health institution, which is very relevant.
yes.
This fund, which means from here that the state, the union is going to give this fund. It has formed the basis that look here for one woman, this is the fund the state will have. The state has to provide these benefits. And this is the fund which you are going to get from the union or replenishment to what you spend.
How was it? As per the last order, I was directed to show with regard to all the beneficiaries are given under the JS.
No, we are not required. We require only this. I think this is the most important line, paragraph 5.
Because whatever this is uploaded in the ministries.
What affidavit you filed?
Yes.
When? When did you file?
Affidavit filed on 27 February.
1st May?
Lordship.
27? What is this? 1st May affidavit file. So this is the same thing, no?
27 February.
Why I am having two copies? Whether you have it? Huh? Why there are 2 copies? 19 February you have. Again, the 19 February he has filed. Filing on the, oh, there was some mistake or something like that. Why there are 2 copies? The same thing. Gauhati has filed it twice. Anyways. Understood, but it is the same thing. Anyways. Your affidavit is dated
27 February.
Okay. Yeah.
Question, as per the direction of the court, on 6/12/2023, paragraph 5, with regard to Mon District Hospital. You can see the order of the court. In view of the issue raised by the petitioner with regard to non-payment of the entitlement to be given to pregnant and children under JSS scheme, the respondent want to force also state in the affidavit that expenditure incurred in giving eternal pregnant women and children JSSK for the month of October in the respect of the district hospital law. The affidavit should clearly clarify the expenditure incurred in relation to the government by cash and by way of kind separate. So we pay in cash. This is a direct benefit transfer.
So this paragraph is relevant, paragraph, the last subparagraph of paragraph 3.
Yes.
So only as regards that and ambulance,
Yes.
you give it the DBT.
Yes. Correct.
Rest, you do it by yourself.
Yes, because we have the ambulance, we keep the.
That is not the case, Lordship.
Let them do them.
Lordship.
That we are not doing it.
Lordship,
Without
now
specific
allow me to
allocation, Lordship.
kindly apprise this court how how treatment is done, Lordship. Say, for example, people, women in a far-flung, in fact, Lordship, this court has, the single bench of this court has also passed an order uh, in- uh, imposing a exemplary cost upon the state, Lordship. Although that case is under challenge by the state, Lordship. Seeing the pathetic condition of the health facilities, Lordship, which is also in evident, like earlier today also 24 PIOs were taken up, Lordship. So the health conditions are very pathetic, Lordship. Now, if a person has to form a village, connectivity is also again a problem. Now, for instance, a pregnant woman, say from parent, they have a district hospital, but they have to travel to Dimapur, Lordship, Dimapur district hospital for delivery also, Lordship. Even recently, Lordship, I have visited with the State Human Rights Commission along with the chairperson and the staff's, Lordship. The same issue was raised. Women from parent district, parent town, they have a district hospital, but due to lack of facility, they're going all the way to Dimapur
Madam,
district
I
hospital.
understand everything, but the one thing is this, see, earlier case has already said that if anybody is aggrieved, they can very well approach these authorities. The pursuant thereto, they came up with this funding.
Lordship.
Now they say that look at for the purpose of food, as the patients like to have their own food, we make a DBT, direct bank transfer or direct benefit transfer. And for ambulance also, they like to come by themselves, so we make a DBT. However, all other things we do it by ourselves. That is so, they stand.
Lordship.
So that 2019 thing has already gone in view of this specific stand. So if you don't get those two, you can very well approach. If you don't get the others, now as per their stand, you can very well approach. Because you see, it has now the case of an individual. This court cannot take judicial notice further beyond that because
Lordship.
there is already a direction. being
Lordship,
passed.
I appreciate. Lordship, I
You do
appreciate.
one thing, madam, just think about it. You take it up on Friday. On Friday, you just, I think this is a matter where taking into account these, that they have already stated that. And paragraph number 5 being quoted out there, being brought to their attention that why they want to do it. They don't actually, the intention behind the scheme is that they should not pay any amount.
Yes, Lordship.
Yes, they
Yes,
should not pay any amount.
exactly.
Yes. And as such, it may not be. There might be certain cases of complications. If there is a case where it is the child has to stay for more. Or it may be a case where the mother may require further diagnosis on account of something must have happened, something required. So these will also be covered in terms with that because this has anything to do with the So we can dispose of this matter by putting, first going into the particular scheme, what it says, what are the benefits which are given, then coming into the 2019,
Lordship.
then say that this 2019 basis can be seen from their affidavit
Yes, Lordship.
and what they say, and then paragraph 5, and now they say that they are going to do. So under such circumstances, if anybody is agree, can very well go if they are not given this benefit.
Yes, Lordship. Yes.
As to the earlier order.
Lordship, yes.
I think that is this for this. That is the best.
Yes, Lordship.
Because there's already an authority appointed in the district also, they can approach. If they are not getting the benefit.
No,
and
that is, therefore it becomes individual then.
Yes, sir.
Lordship.
True.
But unless an observation is made by this honorable court, Lordship, it will be remain futile because the reason why this petition was filed is because of the cap, the ceiling in benefits that has been put.
No, no, you
Lordship.
see, the reason why you have filed is very true. Because at the state's notification of 2019 does not say, they say that we are only going to give you this,
Yes, sir.
which may not be, may not recompense the expenses actually made. So it may be, you are right in coming before this court, which is otherwise not the mandate of that. Later on, now in view of that affidavit which was filed pursuant to the order dated 6/12,
Yes.
makes it very clear
Yes.
that basically they are not going to do so. There might be a thing where the state may also like to bill, because the state is going to spend the money, and the state will be reimbursed this amount.
Yes, Lord.
Just by example, something like if you look at this fair price shops, and you have this nowadays, you get this thing, what is called the rations.
Under the National Food Security
FSA.
Act. Yes.
FSA.
Food Security
Now,
Act.
if you see they have a rule, in that rule it categorically mentions, more particularly I think rule 6, categorically mention as to how much amount the state will be given for deferring
Yes,
the
Lord.
cost. So the state gets that particular amount, how much the space spends, that is their lookout.
Yes.
That is their lookout, but they are to arrange this, and this amount, they will get it from them, the central, when they give for the utilization.
Lord.
So what to do? Dispose now?
Worship has rightly pointed out the issue.
Yes,
Is,
Lord.
yeah,
If the lordships are willing, that matter can be disposed of.
Today she didn't, need not come again on Friday. The Wednesday council.
In fact, the response given, the affidavit of the central government concur with with my, with the issues raised in this petition, Lordship. And also, yes, the scheme says there should not be any out-of-pocket expenses from the women. Because we have to, the scheme covers only the public health facilities, not the private, Lordship. And mostly it is the poor people who goes to the public health facilities. That is why,
This has to be public,
yes,
it can't be private.
it can be, Lordship.
No, you can't say going for a private. One has also to see if we say anything about the private, it will the burden which the state may have to incur. It will be too much.
Yes.
In fact, I still remember during the COVID period, in Assam, they took a thing that they were, the GMC and all these hospitals were so filled up. So they asked the private hospitals to take it.
Yes, Lord.
The amount of billing the private hospitals take, then the government took a decision, let us now empty many other places and have it as beds out there.
In fact, Lordship, the same matter was raised before the Honorable Manipur High Court, Lordship. And the High Court has quashed the ceiling, Lordship, saying that I have also enclosed it in my petition. It's in page number 90, Lordship, the relevant portion. Let's say that since the central government is giving the money, the state should not.
No. The High Court did not consider there that the ceiling is fixed by the central government. That is the problem. He does not feeling that. Actually, this ceiling, madam, the ceiling is not because of that. has been a wrong understanding by the state of Nagaland that we are going to give you this amount. There's nothing to do. For the purpose, if there is an expenses of there, any other expenses which are incurred, it's for them to pay.
Yes, Lordship.
No, but how much they will reimburse to the state is fixed. But we are going to pay you this. Just for example, I give you an example. If you go to a private hospital, by anybody goes to a private hospital, the doctor may charge you for visiting 1,800 or 2,000 or 5,000, whatever. But if you go under the central government scheme, you know how much the doctor charges? His fees. But that is fixed. Like if a person gets in the Ayushman Bharat, why it is 5 lakhs? We see what is this 5 lakhs? It's too less amount. No. These 5 lakhs, the central government or the state government has a tie-up with these hospitals. But they can only be, this is the professional expenses, this is the professional fees of a doctor on seeing these.
Given the private hospital, the empanel.
The empanel, all these empanel, so they will only get this amount.
So many of the private hospitals, they don't want to.
They don't, but they don't, but they, in Delhi and all, big hospitals, they do. Because there is another question of CSR, which is also important.
Lordship, if I would just allow me to quickly take you to the order passed by the Manipur High Court, Lordship. In a similar case, Lordship, Lordship, it starts from page number 87, Lordship. And here also, Manipur state of Manipur has put a ceiling, Lordship. That is why the petition was, the ceiling was challenged.
Where?
Lordship, in page number 87.
No, this is paragraph 9, page 90.
Yes, paragraph 90.
If page 90 is the thing, the court have taken into consideration without taking that it is the central government which is fixing the ceiling.
Lordship, if you would kindly allow me to correct it, one would find that expense to meet out the pre-entitlement is to be borne by the state government, but fund is made available by the central government. Still, the state government has put a cap over it by limiting the expenses as has been shown above, meaning thereby that the state government would not be meeting expenses more than what has been shown above, which is not only in derogation of the scheme launched by the central government, rather it is beyond its competence/authority. Under the circumstances, the cap which has been put in for limiting the expenses being illegal and arbitrary is hereby set aside. Under the circumstances, the respondents are hereby directed.
The court did not consider that the ceiling is not by the state government. The ceiling is done by the state government at the instance of the central government. And this is very clear from the affidavit which is being filed by the central government. To say that yes, we have fixed it for 2000, 2000. But therefore, the interesting aspect is paragraph number 5.
Lordship. Yes, Lordship.
Which is your answer that irrespective of if there is a question of complication, in their affidavit, in their paragraph, the third subpara, the subpara 3 of paragraph 3, that they say that only DBT is done in respect of the food as well as the other, what you call, this taxi or automobile, ambulance service.
Transportation.
But as regards the others, they are going to make direct DBT.
Lordship.
Let's not refer to the Manipur. The instant public interest litigation has been filed by the petitioner challenging, seeking directions for removing all ceiling of benefits capped under the JSSK scheme in the state of Nagaland, and to ensure that the pregnant woman and sick newborn are given the various benefits which are mandated in terms with the said JSK.
जननी शिशु सुरक्षा कार्यक्रम.
There, yeah. So I'm directing the respondents to remove all the ceiling of benefits kept under the Janani Shishu Suraksha Curriculum Scheme, for short JSSK. Scheme ID. Curriculum. In the state of Nagaland, and to ensure that the pregnant woman and sick-born are given the due benefits in terms with the state's scheme. As well as other consequential directions. It is seen from the reports that in respect to the said scheme, JSSK scheme, earlier, another public interest litigation was filed, which was registered as PIL number 19/2017. This court, after taking into account the said JSSK scheme and hearing the parties, disposed of the same with the following directions, which is reproduced, which have been mentioned in paragraph number 11 and 12 of the said order dated 27/5/2019. Paragraph 11 and 12 of the said order being relevant is reproduced herein under. Pursuant to the said order dated 27/5/2019, a notification was issued on 24/6/2019 by the Nagaland, by the State Health Society, Nagaland National Health Mission, Government of Nagaland, whereby entitlements quantified in rupees were mentioned against each of the benefits which were provided by the JSSK scheme. In the case of the petitioner in person, the petitioner thereupon had approached this court, stating that this capping by the amounts, this capping of the services, the benefits by quantifying it in an amount by quantifying it with money is not only meager to the actual expenses which would the a patient, a pregnant woman or a newborn child may have to spend. And as such, the entire scheme, JSSK, the benefits of the scheme, JSSK scheme, have been taken away by the said notification dated 24/6/2019. It is under such circumstances the instant petition has been filed. Before further proceeding, this court finds it very pertinent to take note of what are the actual benefits which the JSSK scheme provides, as the same would have a relevance in, say, instant public interest litigation. The entitlements as per the JSSK scheme are twofold. First is in respect, first are entitlements for pregnant women, and the second, the entitlements of sick newborn till 30 days after birth, the details of which are enumerated, are stated here in under. First, entitlement for pregnant women, page 48. Then, entitlement sick born till 30 days after birth, 49. Pursuant to the filing of the instant public interest litigation, it is seen that various pleadings have been filed. However, it is very pertinent to take note of an order passed by this court on 6/12/2023, whereby this court directed the Union of India to file an affidavit showing the unit cost per beneficiary which have been made by the central government for the JSSK scheme and the basis of the manner in which the same has been calculated. In addition to that, this court had also directed the respondent number 1 to 4 to file an affidavit giving details of the expenditures incurred in giving the entitlement to pregnant women and children under the JSSK for the month of October and November 2023 in the respect of the district hospital Mon. The said affidavit, which was to be filed by the respondent number 1 to 4, were also to contain the expenditure incurred in relation to the entitlement given by way of cash and by way of kind separately. In pursuance to the said order, the Union of India filed an affidavit on 19th of February 2024 Paragraph 4 and 5 of the said affidavit is reproduced hereunder. A perusal of the above two paragraphs of the affidavit filed by the Union of India shows that it is the central government who had shows that the National Health Mission provides financial support to all states of the union territories for implementation of various programs, including JSSK in public health institutions. It is the central government who provides the funds based on a unit cost per beneficiary, which is proposed in the proposals submitted by the state oblique union territory. It is further mentioned that the state of Nagaland had provided the unit cost per beneficiary in the ROP 2022-24 and basing on their proposals, the unit cost per beneficiary have been approved. It is further, it's very relevant to take note of that the Union of India duly states that the budget which is being provided is like a flexi fund, which is only for indicative purpose and not a norm. It has also been categorically admitted that the requirement of funds may vary on the basis of severity of the complications of the case. It categorically states that the objective is of the scheme is to utilize the allocation of funds in such a way that no out-of-pocket expenditure is incurred by pregnant women at a public health institution. Therefore, from the said affidavit, which have been filed by the Union of India, shows that the per, but that the unit cost per beneficiary is submitted by the state of Nagaland on the basis of making due calculation as to the expenditure to be incurred for granting the benefits which are stipulated in for the purpose of calculation, for the purpose of calculation, have from the said affidavit, it is therefore clear that the state of Nagaland had submitted the unit cost. It appears that the unit cost is based upon the assessment being made by the state of Nagaland as to how much they are required to be recompensed against the services so provided in terms with the scheme to the beneficiary. It is also clear that the scheme categorically mandates various entitlements which are already mentioned herein above, as well as the objective of the scheme is that no pregnant woman has to incur out-of-pocket expenditure at the public health institutions. This court further finds it relevant to take note of the additional affidavit so filed by the respondent numbers 1, 2, 3, and 4 pursuant to the directions so passed on 16/12/2023. Huh? 6. 16 was closed. Huh? Last day was 15th. From the said affidavit, more particularly paragraph number 3, would show that the state of Nagaland, this is the by the not the government of Nagaland, by the state health commission, health mission, that the state health mission, in pursuance to the JSSK scheme, categorically provides all other benefits as per the entitlements of mentioned in the scheme, save and except benefits pertaining to diet services as well as ambulance services, which are made directly, which are given direct benefit transfer. This is being done by the state health mission on the ground that the patients are reluctant to avail food from the hospital. And the ambulance service entitlement from the hospital. And as submitted by Mr. Mozui, the learned counsel appearing on behalf of the National Health Mission, Government of Nagaland, on behalf of the respondent numbers 1 to 4. The ambulance services, in lieu of the ambulance services, the direct benefit transfer is given so that the patients can come on their own. Therefore, a conjoint reading, this court have duly heard, we have duly heard the petitioner in person, as well as Mr. M. Mugil, the learning counsel, appearing on behalf of the respondent number 1 to 4, and Mr. Yangavati, the learned central government standing counsel, and have duly taken note of their respective submissions. A conjoint reading of the scheme, JSSK scheme, along with the affidavit filed by the union on 19th of February 2024. The relevant portion of which have already been quoted, as well as the affidavit filed, additional affidavit filed by the respondent number 1 to 4, shows that the National Health Mission provides the funds against unit cost on a unit cost per beneficiary. The unit cost per beneficiary is fixed by the state of Nagaland, or by the states oblique the union territories. And on the basis of the assessment, so on the basis of their individual assessments, the state of Nagaland had provided the unit cost in the year 2019, and subsequently again had submitted for which have been approved for ROP 2022 and 2000-24. The submission of the unit cost by the state of Nagaland in the instant case to the union, but to the National Health Mission, has no connection, in our opinion, to the benefits which the petitioners herein, the beneficiaries, would be entitled in terms with the JSSK scheme. The unit costs so submitted based on the assessment made by the state of Nagaland is only to recompense the state of Nagaland by the National Health Mission against each beneficiary. This aspect of the matter is further clear from paragraph number 5, which stipulates of the affidavit of the Union of India, which categorically states that in view of this JSSK scheme, no out-of-pocket expenditure is to be incurred by the pregnant woman at public health institutions. The state, by filing the additional affidavit, also categorically mentions that all the benefits under the scheme is provided free of cost in the public health care institutions, save and except save and except food as well as ambulance services for which direct benefit transfer have been given. Under such circumstances, in view of the specific stand being taken, in our opinion, the rights of all the beneficiaries, who come within the JSSK scheme are not affected in as much as they are entitled to all the entitlements which have been quoted here in above, which have been mentioned here in above. And the quantification of the amount against each service is only for the purpose of being paid by the union to the state, which has nothing to do with the entitlement to avail the benefits under the JSSK scheme. Under such circumstances, this court therefore disposes of the instant public interest litigation, thereby observing that the beneficiaries under the JSSK scheme would be entitled to the benefits under the said scheme, and if they are aggrieved, they can duly take recourse to the remedies available to them as have been already held by the coordinate bench of this court in its order dated 27/5/2019 in PIL number 19/2017 at paragraph number 11 and 12, which have already been quoted here in above. With the above, this public interest litigation stands closed. We express our gratitude to Ms. So-and-so, the learned petitioner in person, for bringing to the attention of this court the instant matter.
For hearing, item number 51.
Yes, anything?
Not a matter.
Which one?
Like, yeah. Well, we've been made a party in the writ petition. Worship, the State Bank of India has got nothing to do with it. According to the office.
What is this matter about?
I have not received the appeal memo, so it's part of the direction of this.
You are a party?
Yes, I've been made a party in the case. I'm for respondent number 2.
Accountant General?
Yes, and this is a State Bank of India matter, Lordship. State Bank of India employee.
Why you are me? You have no business.
I have no business, Lordship.
Where is the plaintiff? You. Who is going to do the matter?
Your Lordship, item number 51. Item number 51.
You want to do it?
No, you.
You want to do or no? If you don't want to do, don't do.
What if actually only filed additional affidavit?
Huh?
Additional affidavit, document.
Yes, Your Lordship, we have filed one this affidavit in reply.
Then
Yes.
you have not given a copy to him.
No, we have already submitted today.
You
So
have not given the main appeal to him. First in the petition. There. Deleted.
Yes. Over again, when the appeal was filed, I've been directed.
Okay, if we dismiss the appeal, we impose the cost. What do you say?
Lordship,
What do you want now?
Lordship, as I'm not aware of this case,
So your senior is
I'm-
not there.
yes, yes, Lordship. Lordship, my senior is indisposed as he is in Guwahati.
Okay.
And
The co-
for the past
the
few,
counsel appearing on behalf of the appellant. For accommodation, is the matter of 2 3 weeks.
much of,